Pardon to mention before your lordship, this is fresh admission matter of 2022. The matter has not been listed.
Pardon to make a mention. My lord, one modification of order in pending. My lord, kindly list any take out the matter in any supplementary list. My lord, we will give it.
Pardon to mention, my lord, serial number 694 of 2018. Petitioner custody since 5 years, my lord, out of 10.
Give it.
Bail matter.
My lord, tied of bail matter.
Give it. Give it.
Pardon to mention, my lord, weekly list 218 SC/ST bail 60 years aged, my lord. Only 506 non-bailable offense.
Why are you mentioning? I'll go serially. Yes.
It may not come, my lord. On list only 506 notice has to go. Notice has to go. SC/ST fresh admission matter.
Notice has to be 60 of 218.
Notice has to go, my lord.
Which item? Which item?
219. Weekly list.
Why are you making mention now?
This may not be come, my lord.
Yes, next.
Supplementary list item 1.
Okay, peruse the letter dated 18/7/2023 of the Lenin additional session just comes special discontamar. In connection with
witnesses, 12 witnesses
ST case number 50 of 2018, 3 months further time is granted for disposal of the case trial. Communicate the order to the Lenin trial court. Yes.
Item 2.
May please, my lord. Here, my lord, your lordship has been pleased to grant bail to the petitioner with the condition that the petitioner shall deposit 25% of the financial implication against the present petitioner, my lord. That amounts to rupees 4,80,000. My lord, even my lord, 2 months of passing this order, my lord, the petitioner could not get the benefit of that order, my lord. Because, my lord, the present petitioner, my lord, they belongs to scheduled tribe category, and also they are BPL category persons, my lord. Further, my lord, I have filed an affidavit in the bail application, which shows that by the letter submitted by the prosecution side, that though an amount of rupees 4,80,000 has
your
been
instruction
credited
on this interim application, file the affidavit of the IO. He has taken some ground that about his condition, financial condition, all these things. So file an affidavit of that investigating officer.
And one more thing, my lord, I filed the affidavit in the bail application, annexure 6, my lord, that is letter of the prosecution, which shows that only 1,67,000 has been withdrawn by the present petition.
945 of 2023. This is an application.
IA number 945 of 23, madam.
An application for modification of the order dated 16/5/2023. The Learning Council for the state submits that he has received a copy of the interim application and intends to file an affidavit of the investigating officer to the interim application. Please, this matter will be commencing from 7th of August 2023.
Item 3.
May I please, lordship. My lord, the petitioner is a HIV positive patient, my lord. I have filed an application for extension of interim bail, my lord. Your lordship released the petitioner on interim bail for a period of 3 months, my lord. And on previous occasion, this honorable court also granted interim bail in BL APL number 5455 in that ground, my lord. And also thereafter released on interim bail by this honorable court.
Surrender will see. The is an application for extension. After going through the grounds taken, I am not inclined to extend the period of interim bail. Stands dismissed. Yes.
Lordship, I have filed his medical certificate, my lord.
File. Yes, next, another application. Yes. Next. Call the matter serially from 66 onwards. Yes. Mr. Das, what is this matter? Stay of conviction.
Stay of conviction, my lord.
You have filed your objection.
Yes, my lord. Since law. Copy has been served.
Where is Mr. Milan Kanungo?
6/4/2023.
Passo. Are you showing it in the display? Okay. Okay. $67. All right. Continue.
Item 68.
My lord, the matter can be taken up 1 week after.
You are to supply the deposition copy of the victim.
Not yet collected at the lower court.
The learned counsel for the appellant seeks some further time to produce the certified copy of deposition of the victim. List this matter. Give a date after 2 weeks.
Uh, 67. 67.
Yes.
67. 67.
Yes.
I am for the appellant.
Argue your matter.
ମିସକେସ୍ ଗୋଟେ ଅଛି ୱାନ୍ ମିସକେସ୍ ଅଲରେଡି ଇନଫ୍ରାକ୍ଚୁଆଲ ଯୋଉଟା ଷ୍ଟେ ପାଇଁ ଆମେ ଫାଇଲ କରିଥିଲୁ ଅଲରେଡି dismissed from the service.
That is IA number 326 of 23.
My lord.
Then what is this appropriate order?
Another, my lord, for preparation of the paper book, my lord. Because
How can in 23 matter you will be allowed to argue the matter? What about the older appeals? When the older appeals are pending, how a 2023 appeals will be taken off for hearing and preparation of paper books?
paper book ଟା ରେଡି କରି ରହିଲେ ଆଉ ତାପରେ ହିୟରିଂ ଯେବେ ହଉଥିବ at our cost.
So you don't want to press this 326?
No.
All right. IA number 326 of 2023. This is an application for stay of impugn judgment The Learned Counsel for the appellant doesn't want to press this application on the ground that the appellant has already been dismissed from his service. In view of such submission, I stands disposed of.
My presence may kindly be noted.
Mr. Sanjay Kumar Das, Learned Standing Counsel for the Vigilance Department, is present. है ना?
I have supplied
Next.
the objection.
He submits that he has already filed the objection affidavit. Okay, disposed of as not pressed for the other. Okay, then IA number 112/2023. This is an application for, what is this application for?
For preparation paperwork at the cost of the appellant.
What is that IA? This is an application for issuance of necessary direction to prepare the paperwork at the cost of the appellant. Let the you will prepare the paperwork.
My lord,
All right. The Land Counsel for the petitioner submits that the appellant will prepare the paperwork. Required number of people and file the same. And for such purpose, he wants 1 month time, 4 weeks time. Time is allowed.
Okay.
Yes, next.
May I pray for today's orders of free copy?
Free copy of the order will be handed over.
Obliged.
Item 69,
69, my lord. Offense under section 376 AB and 6 of POCSO Act, my lord. The date of judgment, my lord, that is 16/5/2022. Date
Have
of
you,
occurrence
have
is
you
9/11/1999.
given the deposition copy?
Yes, my lord. Sorry. The prosecution story, my lord.
You were on
Yes,
bail.
yes.
Huh?
PW1 is the victim.
You were on bail during trial.
No, my lord.
Then what is the sentence?
Sentence, my lord. 20 years, my lord.
Since when you were in custody?
Since date of arrest, that is from 9/11/99 to 2009 to 2019. Lord.
9th November.
My lord. 2019, my lord.
PW1 is the victim.
Victim, my lord.
Doctor is PW.
16.
16.
Who is the informant in this?
In fact, the mother,
PW2.
father of the victim, my lord. PW2.
What is the date of occurrence?
Date of occurrence, my lord, 8/11 to 219, my lord.
8/11.
Yeah. Para 6, page 12. The
Para 2, chief examination.
I'm leading the prosecution case, my lord, that on dated 8/11/2019, the accused took the victim, the minor daughter of the informant, from his house when no male member was present on the pretext of giving chocolates to her. He took her to a lonely place at the backside Bari and committed rape on her by inserting her penis into the vagina of the victim. The victim girl returned home at about 9 p.m. crying and narrated the incident. On 9/11/19, the informant lodged the affair, after which investigation was taken up. Under para 6, page 12, the victim PW1 in her evidence has stated that about 2 years back from the date of deposition, that is 24 November 2021, at evening time, while she was sitting at their danda front side of her house crying, the accused called her to one gunduri shop and gave her 2 chocolates. She ate 1 chocolate, then the accused gave another which she ate. Then the accused took her to the backside of her body, removed her panty, and laid her down on the floor. Then he slept over her and embraced her. The accused removed his lungi and sat over her and tried to insert his finger into her private part, as a result of which she sustained injury on her private part. The accused threatened her not to disclose the same to her family members. And my lord, the doctor is my lord. That is a para 13, my lord. Para 13, my lord, page 18. The medical officer, P.W. 16, in her evidence has stated that on 10/11/29, she examined the victim as well as the accused, but she did not find any mark of injury to suggest any recent sign or symptoms of sexual intercourse. She could not find any external or internal injury on the person of the victim. She collected the samples of blood, the victim, and the accused for the chemical examination, but the accused refused to her collection of the semen.
How
So
many
the semen
cases
of the
are there,
accused could
Mr.
not be collected. My humble submission, my lord,
About the
the
criminal
victim accepted
Criminal
that
activities.
she tried to insert, my lord, her finger, my lord.
About any criminal antecedent?
I have no instruction, my lord. I think
No instruction, my lord.
The Learning Council for the state seeks some time to obtain instruction about the criminal antecedent, if any, against the petitioner. List this matter will be commencing from 7th August
my lord.
2023.
Item 70.
I'm sorry, my lord, today I'm in VC, my lord, I'm not well. But item 70, last occasion, my lord, was pleased to call for the social investigation report, my lord.
It's a case under section 302.
Of 34 IPCS, my lord. And the appellant for lordship is a juvenile. Initially,
So what are the materials, Mr.
yes, my lord.
Misra?
Yes, it has come, my lord. That's my lord.
No. What? Who has stated against this petitioner?
Since the petitioner, my lord, initially FIR was lodged against unknown person, my lord.
Petitioner's
Subsequently,
name?
charge sheet was filed.
Just a minute. You are
Statement of one Nandalal Jadhav.
you are detained in observation home.
Yes, my lord.
So since when?
Since 11/11/2022, my lord.
Charge sheet offenses are
302/34 IPC.
what is the name of the deceased?
This is that Kanta Kemut, my lord. Kanta Kemut.
Date of occurrence?
23/10/2022.
Eyewitnesses are there.
No, my lord. No, my lord. No. Your lordship, kindly come to page 33, my lord. Page 33 and 34.
Wait. What is the you said that FIR was lodged against unknown person.
Unknown. Yes, my lord.
Then on suspicion, this man boy was detained or what? What
Yes,
materials are there, Mr.
So kindly
Misra?
come to page 33.
Judicial confession and
Extrajudicial confession.
yes,
Before whom? Who is that witness?
Nandalal Jadhav.
That statement you have annexed, Mr. Joshi.
Yes, page 33, my lord. One Somnath Majhi, his 164 statement was recorded, but he is not an eyewitness to the occurrence.
No, he is telling about one Nandalal. Please place that Nandalal Yadav state. Let us see that what he has stated.
ମୋର ନାମ ନନ୍ଦଲାଲ ଯାଦବ, ପିତା ରାମଚନ୍ଦ୍ର ଯାଦବ, ଗ୍ରାମ ମୋଟା ନୂଆପଡ଼ା, ଥାନା ଧରମ ବଜାର, ସ୍ଥାୟୀ ବାସିନ୍ଦା ଅଟେ। ଆଜି ତା 29/22 ଦିନ ଆପଣଙ୍କ ପାଖେ ଦେବା ମୋର ବୟାନ ଏହିକି ଯେ ଆମ ଗାଁରେ ଗ୍ରାମର କାନ୍ତା କେଉଟକୁ ଗତ 23/10/22 ସକାଳ 8ଟା ବେଳେ କାନ୍ତା କେଉଟକୁ ମାଛ ଜାଲରୁ ମାଛ ଆଣିବା ପାଇଁ ତାଙ୍କ ଜମିକୁ ଯାଇଥିଲା। ସକାଳେ ଖବର ପାଇଲୁ ଯେ ଆମ ଗାଁର କାନ୍ତା କେଉଟକୁ ମାରି ଦେଇ ରାସ୍ତାରେ ପକାଇ ଦେଇଛନ୍ତି। ଏହି ବିଷୟକୁ ରିପୋର୍ଟ ହେବା ପରେ ପୋଲିସ ତଦନ୍ତ କରି ଆମ ଗାଁର ଦେଓସିଂ କେଉଟକୁ ଗିରଫ କରି କୋର୍ଟ ଚାଳନା କଲେ। ଗତ 7/11/22 ଦିନ ମନୋଜ କୁମାର କେଉଟ ଏବଂ ମନୋଜ କୁମାର କେଉଟ ଆପଣଙ୍କ ଆଦେଶ ମୁତାବକ ନୂଆପଡ଼ା ବ୍ଲକ ଉପାଧ୍ୟକ୍ଷ ଦିଲ୍ଲୀପ କୁମାର ନିର୍ମଳ କର, ସରପଞ୍ଚ ମୋତିଲାଲ ଉଜିର ଏବଂ ଆମ ଗାଁର ଭଦ୍ର ବ୍ୟକ୍ତିଙ୍କ ଉପସ୍ଥିତିରେ ଗୋଟିଏ ମିଟିଂ ହେଲା। ଉକ୍ତ ମିଟିଂରେ ଆମ ଗାଁର କାନ୍ତା କେଉଟକୁ ମାରିଥିବା କଥା ପ୍ରକାଶ କରି କହିଲେ ଯେ
Who stated that?
this present petitioner.
No. Present petition name is Tara Chand Keut.
Yes, madam.
You read somebody else's name. Please read it. Read it once again.
Madam, I'm reading, madam. ଉକ୍ତ ମିଟିଂରେ ଆମ ଗାଁର କାନ୍ତା କେଉଟକୁ ମାରିଥିବା କଥା ପ୍ରକାଶ କରି କହିଲେ ଯେ କାନ୍ତା କୁମାର କେଉଟ ହାତ ଦୁଇଟିକୁ ଧରିଥିଲା ଓ ତାରାଚାନ୍ଦ କେଉଟ
ତା ପୂର୍ବରୁ ଆଉ ଟିକେ ପଢନ୍ତୁ।
ଗତ 7/11/22 ଦିନ ମନୋଜ କୁମାର କେଉଟ ଏବଂ ଆଦେଶ ମୁତାବକ ନୂଆପଡ଼ା ବ୍ଲକ ଉପାଧ୍ୟକ୍ଷ ଦିଲ୍ଲୀପ କୁମାର ନିର୍ମଳ କର, ସରପଞ୍ଚ ମୋତିଲାଲ ଉଜିର ଏବଂ ଗାଁର ଭଦ୍ରବ୍ୟକ୍ତି ମାନଙ୍କର ଉପସ୍ଥିତିରେ ଗୋଟେ ମିଟିଂ ହେଲା। ଉକ୍ତ ମିଟିଂରେ ଆମ ଗାଁର କାନ୍ତା କେଉଟକୁ ମାରିଥିବା କଥା ପ୍ରକାଶ କରି କହିଲେ ଯେ ମୀନା କୁମାର କେଉଟ କାନ୍ତା କେଉଟର ହାତ ଦୁଇଟା ଧରିଥିଲା ଓ ତାରାଚାନ୍ଦ କେଉଟ ଗୋଡ ଦୁଇଟାକୁ ଧରି ଥିବା କଥା ପ୍ରକାଶ କରି କହିଲେ ଯେ ଦେଓସିଂ କେଉଟ ସେ ଧରିଥିବା
କିଏ କହିଲେ? You are telling that it's an extrajudicial confession. So who confessed?
That is not specifically.
That's not there. Then what else is there? You said that there is no eyewitnesses to the occurrence.
Yes.
And FIR is lodged against an unknown person. And you read out that Nandalal Yadav statement from which it doesn't appear that there was any extrajudicial confession by the present petitioner or present appellant. Then what else is there? Mr. Joshi, what are the materials?
Yes, you'll also kindly come to page 33, my lord.
Yes.
One, during inquest of investigation, one Somnath Maji and one Yadav Kumar Rao, their 164 statement were recorded. Page 33. He was not an eyewitness to the occurrence.
No, what they have stated, those two witnesses?
Yes, page 33, my lord. One Somnath Maji.
ପୁଅ ମନୋଜ କୁମାର କେଉଟ କହିଲା ଯେ ସେ ସନ୍ଦେହ କରୁଛି ଆମ ଗ୍ରାମର ତାରାଚାନ୍ଦ କେଉଟ ସୁଆଂଶକୁ ବାପା ମାରି ଦେଇଛନ୍ତି। ଉକ୍ତ ତାରାଚାନ୍ଦ ଓ ନିମ କୁମାର ସେହି ମିଟିଂରେ ଉପସ୍ଥିତ ଥିଲେ। ସେମାନେ କହିଲେ ଯେ ସେମାନଙ୍କ ମଧ୍ୟରୁ ନିମ କୁମାର
କେଉଟ ସ୍ୱର୍ଗତ କାନ୍ତାଙ୍କ ହାତ ଦୁଇଟି ଓ ତାରାଚନ୍ଦ କେଉଟ ସ୍ୱର୍ଗତ କାନ୍ତା କେଉଟଙ୍କ ଗୋଡ ଧରିଥିଲେ ଓ ଦେଓସିଂ କେଉଟ କାନ୍ତାଙ୍କ ଗଳା କାଟି ହତ୍ୟା କରିଥିଲେ।
It's not a voluntary one in the meeting.
Meeting was convened at the behest of the ex-sarpanch. Informant was present. He said that he is suspecting this person had committed.
One thing. What else is there?
Besides that, nothing more, my lord.
No, any recovery at the instance of.
At the one knife was recovered at the instance of. Lordship, kindly come to that page. Page 15, my lord.
Yes.
At the instance of one Deosing Keut, serial number 3. One Deosing Keut, one knife, about 23 cm was plastic handle was seized. One Deosing Keut.
What is there in that social investigation report, Mr. Misra?
Yes, ma'am.
Any other antecedent or anything?
No.
So what is the conclusion part is there? What this boy is doing now?
He studied up to standard 5.
Okay.
The reason for leaving school is to earn and support the family.
Okay.
Little of school studied at government school. Majority of friends, same age group.
Hmm.
Reason for alleged offense such as parental neglect or overprotection, peer group influence to take revenge, suspecting death of his elder sister-in-law, namely Kamala Keuto.
No CA, no criminal line.
No criminal.
No,
Or
my
the
lord.
land counsel for the petitioner, land counsel for the state. The land counsel for the petitioner submits that the petitioner is juvenile and he is detained in observation home since 11/11/2022 and he has been charge sheeted under section 302 by 34 of the Indian Penal Code. The occurrence in question took place on 23/10/2022 and the first information report was lodged on the very day by the son of the deceased,
Manoj Kumar Kemp.
Manoj Kumar, namely Manoj Kumar Keuta. When he found that the dead body of the deceased, Kantha Keuta, was lying with bleeding injuries on their land. The FIR was lodged against unknown persons. The Land and Counsel for the petitioner further submits that there are no eyewitnesses to the occurrence. The case is based on circumstantial evidence. And though it is the prosecution case that a village meeting was convened where the petitioner and another co-accused confessed their guilt, but it seems to be a stage-managed one and cannot be said to be a voluntary. Land Counsel further submits that there is no criminal antecedent against the petitioner, and in view of the Section 12 of the Juvenile Justice Care and Protection and so Act, the bail application of the petitioner may be favorably considered. Land Counsel for the state, on the other hand, opposed the prayer for bail and placed the statements of witnesses to the dying extrajudicial confession, that is Somnath Majhi and Yadas
Yadav.
Raut. He also placed the social investigation report and submits that there is nothing adverse in such report against the petitioner, against the appellant. Considering the submission made by the Land Counsel for the respective parties, the nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence, age of the petitioner, and keeping in view the period of his detention as well as provision under section 12 of the so-and-so Act, 2015 Act, I'm inclined to release the petitioner on bail. The operative part would be in a different manner in the juvenile sense then. So yes, allowed.
Much obliged.
Item 71.
Just a second. Okay. Just add these 2 to 3 lines, keeping in view the section 12 and absence of any material to show that the release of the petitioner is likely to bring him into the association with an unknown criminal or expose him to moral, physical or psychological danger, or the release of the petitioner would defeat the ends of justice. I'm inclined to this. Okay. Yes.
May plus. The appellant has been convicted. I filed the deposition copies with flag C and also sought to the
Yes, Mr. Mishra, you have got the deposition.
Yes,
copy.
the conviction under section 372N and 6 of the POCSO Act.
Yes. You are in custody since when?
8/8/2020, my lord.
You have not been released during
No, my
8/8/2020,
yes, ma'am.
and you have been convicted under section 376.
372N and 6 of the POCSO Act, my lord. And the sentence awarded under section 6 of the POCSO Act of imprisonment of 20 years and a fine up to 20,000. That is running page 33.
Hmm. Who is the victim?
Victim is PW4
PW4.
and
Doctor?
PW3. The prosecution, my lord, in order to ascertain the age of the victim, relied the admission register of the Anganwadi worker, in which it is reflects that at the date of occurrence he was 17 years, 10 months and 18 days. PW10 is the Anganwadi worker.
Hmm.
PW4 stated that I am informant of this case. I know the accused standing in the dock. Few days back, once I had been to Jalespota to watch Sivaratri Yatra, the accused met me there and called me to a side and asked me to sit on his bike. When I denied, he proposed me to marry and forcefully made me to sit on his bike, and he took me to his village Bodamudra. When we reached the house of the accused, his family members did not allow me to stay in their house. Then the accused kept me another house and raped me 2 times. Then the accused took me to Hyderabad and stayed there for some months. Due to lockdown, we returned to our respective villages. I was kept in quarantine at village Kottagoda and the accused was kept in quarantine at village Muniguda. After my quarantine period was over, I went to the house of the accused, but the accused refused to accept me and abused me in obscene languages. Then I returned back and went to my sister's house, brother-in-law, and informed them regarding the incident. They had been to the house of the accused to ask about the matter, but the accused also abused them in obscene language and misbehaved them. Then I informed the matter to my brother Subhas Maji over telephone. Thereafter, I had been to the police station along with my sister and brother-in-law and lodged the affair.
But in paragraph number 6, he has stated that
the
about the
conceived there.
conceive, what happened?
But as per my instruction, no child has been delivered.
Yes, Mr.
No instruction has come.
Get the instruction. When the evidence of the victim, bracket PW4, was placed by the London Council for the appellant, it appeared that she stated that at Hyderabad, she was staying with the appellant as husband and wife, and she got conceived there. And a query is made to the learned counsel for both the parties about the status of pregnancy. The learned counsel for the state seeks some time to obtain instruction in that respect to the inspector in charge of Tumudi Bandha police station. List this matter in the week commencing from 7th August 2023. Free copy of the order be handed over to the learned counsel. And also about the criminal antecedent, if any, that also you add. Okay. One thing is status of pregnancy, and the other is CA. Live stream. Okay.
Item 72.
72 prefer 2 after.
You have received the deposition copies?
No, my lord.
Supply the what is the offense here?
20
NDPS.
Supply deposition copy. And how many years you have remained in custody?
4 years going on. Out of 10 years.
Get the custody certificate also. The land council for the state shall of produce the custody certificate. Number 1. Deposition copy to be supplied. Number 2. And is a man outsider?
Local man.
Local man.
Yes.
Okay.
My lordship last
And criminal antecedent, if any.
my lordship last time I mentioned this is legal aid case. Because
you are not having the deposition copy with you.
No.
All right. Since it's a legal aid brief, but it's a registered as CRLA. It's not JCRLA.
Trial court legal aid thila state defense counsel tolo court.
All right, take down the learned counsel for the appellant submits that in the trial court, the state defense counsel was engaged to defend the appellant, and he's having not the copies of the deposition with him. Since trial court record has already been received, photocopy of the trial court record has been received. Let the registry supply the deposition copies of all the witnesses to the learned counsel for the state as well as learned counsel for the appellant. List this matter in the week commencing from 7th August 2023. I would date for the in the meantime, he has to obtain the criminal antecedent. आगु जो मु कहनथि deposition copy supply करिवे सिए बोली सेटा काटी देबे हला आउ criminal antecedent instruction टा ने हला.
Item 73.
Yes.
In this case, appellant was convicted under section 376A(b), 376(2)(l) of IPC and 6 of POCSO Act, Miller.
Have you supplied deposition copy?
Yes, sir.
Notice sufficient. You are appearing.
No, my lord. Copy not received. 23rd.
Just a minute. What do you want?
I am appearing for the opposite party. The copy doesn't receive, my lord.
You have not received the supply.
23rd.
It's already, he has now entered appearance. So let the copy of the appeal memo along with
memo
the.
is there, Miller.
What do you want? Then tell me.
The deposition copy is not with me.
That I'll say. You have got the judgment with you.
Judgment.
Appeal memo, the judgment with you.
My
IA copy, interim application copy is also with you.
my lord.
So you want the deposition copy.
My lord.
You have got the deposition
Yes.
copy. Let the land counsel for the appellant supply the deposition copy of all the witnesses to the land counsel for the informant during course of this week. Matter be listed in the week commencing from what is the offense here? 376 AP. So 7th of August. How many years you are in custody?
4 years and 6 months.
All right, 7/8/2020. Next.
Obli.
Item 74.
Petitioner, my lord, convicted on offense under section, my lord, 304 part 1, my lord. That is RI for 10 years and fine of rupees 5,000 in default 3 months.
Yes.
Yes, my lord, conviction.
Have you supplied the deposition copies?
No, no, man.
ଦେଇଛି ଆଜ୍ଞା ଦେଇଛି କିନ୍ତୁ ସେଥିରେ 26-27 ଟା ନାହିଁ।
amendment you want?
The petitioner, meanwhile, charge has been framed. So initially, the petitioner challenged the case under section 227 of the petition, which was
OPID Act case. So how you will file a 227 application? It is to be filed 239 CRPC application because it is to be tried as a magistrate tribal case. देखिए OPID Act. If I choose to do. Section 15 of the OPID Act says procedure and powers of the designated court regarding offences. The designated court may take cognizance of the offence without the accused being committed to it for trial, and in trying the accused shall follow the procedure prescribed in the Code of Criminal Procedure for trial of warrant cases by the magistrates. So once warrant case by magistrate means the provision is 239 CRPC. So whatever it may be. So your discharge petition was rejected.
Rejected and charge has
Now
been
charge has been framed. When charge was framed?
And the charge framed on 2/3/2023.
Then what has happened?
This one I have filed for amendment as per your lordship.
No, any witnesses have been examined?
Not yet, my lord.
Mr. Patra, what is your instruction? It's not difficult. All right, let the amendment prayer be allowed. Let him file the consolidated petition because some development has taken place. Lekhon, IA number 1187 of 23. This is an application for amendment. The Learned Counsel for the appellant submitted that the appellant Pratap Kumar Vishwal has filed this criminal appeal under section 13 of the OPID Act, challenging the order dated 9/1/2023 passed by the Learned Presiding Officer designated court under OPID Act in city case number 33 of 2019. In rejecting the petition for discharge filed by the appellant. However, in the meantime, the charge has been framed against the petitioner, and therefore he has filed this application for amendment. What is the schedule? Very surprising.
Annexure 7.
Is it way to file an amendment petition? You are to incorporate in the form of a schedule that these are the paragraphs which I want to add in the grounds, and also in the prayer portion I have to change it. I have to add this portion. Once it is allowed, then you are to file a consolidated one. There is no schedule at all in the amendment petition. So you cannot just add that. You have to take some averments also. How you are challenging that order of framing charge. You have taken grounds for your discharge petition was rejected. Now the charge has been framed. So charge is not sustainable in the eye of law. So for that, you have to add some paragraph. In your grounds also, you have to give some, and the prayer portion has to be changed. So for that, at least two schedules are to be given. One, after paragraph number so and so, these paragraphs may be added, and in the prayer portion, this should be added. Accordingly, that has not been done. So you withdraw this, file a better one. The Learned Counsel for the.
My lord, I maybe withdraw the entire petition. I will file a better one.
All right, the scroll out. The Learned Counsel for the appellant submits that since आज ऊपर portion टा था वो जो ये challenge करते ले, since in the meantime charge has been framed, he intends to withdraw the appeal memo and file a better one. The criminal appeal is disposed of as withdrawn. Yes,
Obliged.
giving liberty to the petitioner, giving liberty to the appellant to file another criminal appeal, challenging the order of framing charge. Okay. Yes.
Item 77.
Urgent certified copy.
Certified copy. से ऊपर तक लिखा हो जेएमपीसी challenge करो the discharge petition. Then he seeks permission. Since in the meantime charge has been framed, he seeks permission to withdraw the to file an appeal afresh challenging the order. Okay. Yes.
One more thing, my lord. Then the certified copies may be returned.
Which one certified?
I have filed those.
Acha, the certified copy of framing of the charge, which is annexed to the IA number 1187 of 2023, be returned to the Learned Counsel for the appellant on being substituted with a Xerox copy. Okay.
Obliged.
Mr. Patra's present, we noted also. Mr. J.P. Patra, Learned Counsel, Special Counsel for the State of Odisha in Opiate Act matter is present. Okay. 77, what happened?
On behalf of Mr. S.K.SAHOO, kindly taken up next week.
This is also Opiate Act matter.
Our name may be indicated, Mr. Bhuyan.
Okay. Pardon, Mr. Both name will be reflected.
Both.
The Learned Counsel for the appellant seeks for an adjournment. Mr. J.P. Patra, Learned Counsel, Special Counsel for the Opiate Act, State of Orissa in Opiate Act matter is present. List this matter, give the date according to the indicating the name of Mr. Vivekanand Bhuyan and J.P. Patra in the cause list. Okay.
Item 78.
Item 78, kindly pass over.
What is this matter, CRLA?
Kindly pass over.
Conviction na SC/ST bail?
I have no idea.
Mr. Juvenile matter. All right. That
NDPS matter.
Okay. The Learned Counsel for the pass over. Okay.
Item 79.
Item 79, your lordship. The delay of 23 days.
What is this criminal appeal for?
The criminal appeal for his appellant is convicted under section 376, 363, 366, 376, 506, and section 4 of the POSO Act.
Oh, 376, 3 is there.
Yes, your lordship.
So notice is necessary.
Yes, your lordship.
So you serve an extra copy of the appeal memo along with the impugned judgment and those interim application copies. Since one of the offense under which the appellant has been found guilty is under section 376 bracket 3 of the Indian Penal Code, where it is mentioned 376(3). Right. Convicted which is the operative one.
Running page, my lord, 30. Internal page 30.
Barkolo.
Internal page judgment 30.
30, page number 30.
Page nothing.
376 3 ठीक है. So extra copy to be served during course of this week. You serve the extra copy. Usual order copy. Extra copy to be served. Notice to be issued. 376 3. Yes, next.
Item 80.
May I please, my lord, I'm through virtual mode. My lord, I'm appearing on behalf of Mr. Shyam Manohar. My lord, in this matter, on last date of hearing, my lord has directed the state to take instruction on the interim bail, my lord.
What is the last date?
21/6.
You are required to supply the interim application copy to the Land Council for the state.
Yes, my lord, we have already supplied.
But instruction not received, my lord. Ready next week.
You have already sought for instruction.
My lord.
All right. IA number 1064 of 2023. There is an application for interim bail. The Land Council for the state submitted that as per order dated 21/6/2023, instruction has already been sought for, and is expecting the instruction to be received during course of this week. List this matter in view of such submission. List this matter in the week commencing from 31st July 2023.
My lord, connected appeal.
Along with so and so.
My lord, connected appeal. I filed interim application for bail. I'm serving the copy of the deposition. Your lordship may consider my bail petition is a lady.
These are NDPS matter.
My lord.
It will come next week. Next.
I'm serving the copy of the deposition to the state, my lord.
Okay. The in CRLA number deposition copies of the witnesses served in court. You received it, Mr. Das? Served in court. List this matter. Give the first one, 417 of 2020. Okay.
All right, ma'am.
Item 81.
May I please? Petitioner has been convicted under section 304 part 2 of the IPC.
Just a minute. Have you supplied deposition copies?
Yes, I have supplied on 12/7.
81 matter. Yes, sir.
I received.
Item 81. Are you having the deposition copy?
Yes, madam.
Oh,
304 part 2, madam.
just a minute. What is judgment? What is the operative part of the judgment? Page number?
Page number
30, madam.
8.
What is that?
Running page.
So it is 304 part 2 and RI for 6 years, right?
Mine.
Fine is 50,000. You were on bail during trial?
Yes. I was arrested on 30. My lord, kindly see page 8. Judgment page 2, running page 8. Law and Trial Court clarified.
13/8/2018, your date of arrest, and you are released on bail.
22/8.
22/8. That means 1 year you are in custody.
Yes, my lord. 1 year, 9 days.
And now after conviction,
On the date of judgment,
date of
24.
judgment 24/2023, you are in custody. Okay, what is the name of the deceased?
Deceased, my lord, Lambodar Naik. No, sorry.
Krishna Naik.
Note টা কাই? Food note টা কাই? Sorry, Krishna. Krishna from the roadside, yes.
Date of occurrence is 11/8/2018. So the prosecution examines seven
Seven
witnesses. 1 or 2 are the medicals and investigating
One
officer,
doctor,
rest
two
are the
supervisor,
independent.
three who?
Eyewitnesses is there. Eyewitness there.
Three, though he is not the eyewitness, three, kindly see the three.
PW3.
PW3.
Park trial court record PW3.
PW3. May I place, my lord?
That is Tikayat Naik.
Yes, my lord. Tikayat Naik. On the basis of three and doctor, he has been convicted.
Okay, the dying declaration part he has stated. Because by the time he reached at the scene of occurrence, though the appellant was present, but the assault part was over.
Yes, my lord.
Then while he was shifting the deceased in an auto rickshaw to the hospital, on being asked, he said that I have been assaulted by this Nokulo, means the present.
With the appellant.
Yes, Mr. Das. 6 years is there. And he has already remained in custody, as it appears, about 1 year and 3 months. How many, with the doctor conducted PM?
Dr. Miller, PW1.
PW1.
Intra-abdominal and intrathoracic hemorrhage. Cause of death was due to shock as a result of massive internal hemorrhage. Weapon of assault was a bamboo stick.
Bamboo stick, only bamboo.
PW3 actually not seen the occurrence.
No.
That means he is a post-occurrence witness stated
Oral
about
dying declaration.
oral dying declaration. No one has seen the actual assault, Mr.
No, madam.
Because even PW4 says that he heard screaming and went there. She is the wife of the widow of the deceased.
Yes.
And found that the husband was lying unconscious and
They shifted hospital thereafter.
right.
Only the PW3 saw that he was standing there
Standing there.
and run away.
At the London Council for the Appellant London Council for the State. This is IN number 1009 of 23, an application for bail. Submits that The petitioner faced trial under Section 302 of the Indian Penal Code, but he has been found guilty under Section 304, Part 2 of the Indian Penal Code and sentenced to rigorous imprisonment for 6 years and fine. The Land Council further submits that the appellant was taken into judicial custody in connection with the case on 13/8/2018, 13/8/2018, and he was directed to be released on bail on 22/8/2019. And after his conviction, he is now in judicial custody, and as such, he has remained in custody for 1 year and 3 months. It is further submitted that there are no eyewitnesses to the occurrence. And the doctor who has examined the deceased, who has conducted post-mortem examination over the dead body of the deceased, submitted that the cause of death was due to shock as a result of massive internal hemorrhage. It is further argued that there is no chance of early hearing of the appeal in the near future. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land Counsel for the state opposed the prayer for bail and placed the evidence of PW3 and PW4. So also the doctor bracketly PW1. The Land Council for the state submitted that PW3 has stated about the dying declaration made by the deceased Krishna Naik while being taken to the hospital. Considering the submission made by the Learning Council for the respective parties, nature of evidence adduced during trial, absence of any direct evidence, nature of circumstantial evidence appearing on record, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing. I am inclined to release the, and you are on bail, I'm inclined to release him on bail, stay relation of fine. Yes.
Item 82.
Yes, Mr. Rai. Condonation of delay. What is this criminal appeal for?
Conviction order for 10 years, my lord.
How many days delay?
Delay, my lord, of 1,223 days, my lord.
Only?
Well,
What you are doing?
the rustic villagers, my lord, is in custody since, my lord.
You are required to file an objection, Mr.
File objection, my lord.
Already filed, madam. Yeah, I'm coming.
So it's a NDPS Act case.
No, my lord.
376.
My lord.
So delay is
1223 दिन. And now 6 years more than custody, my lord.
1164 दिन देख. Advocates welfare fund रे दाखल करंतु 20 टंका. तो एते दिन कंडोम करिबे. Deposit rupees 5,000 subject.
That four custody since more than
No.
6 years. Some lesser amount nursing.
Alright, IA number 1018 of 2023 is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 116 days in filing this criminal appeal.
1223 दिन delay.
देखा ହେଇଛି 1166 calculation କଲା ପରେ. The stamp reporter has the Learning Council for the state has filed the objection to the delay condonation application. Copy of the objection has been served on the Learning Council for the appellant. Considering the submission made by the Learning Council for the respective parties, averments taken in the interim application for condonation of delay and objection filed by the Learning Council for the state who's the interim application. And since it's a case of conviction where the Learning Trial Court has imposed 10 years of substantive sentence on the appellant, and it is stated by Mr. Rautre that the appellant is in judicial custody for more than 6 years. I am inclined to condone the delay, subject to deposit of rupees 3,000 in the Orissa High Court welfare fund, and the receipts shall be produced by next date, which is fixed. Mr. Rakivi, is this matter on 31st July 2023. Mr. Rautre, the Land Council for the appellant shall produce the receipt showing deposit of such amount. Yes.
For admission,
Yeah, obviously it will come for admission, but you are to produce that receipt. In other orders will follow. Yes.
Item 83.
Legislates. Here is case of Lordship. The condition of 351, 342, and 34 IPC, and order section 354 and part 2 of the IPC, and 10 section 10 of
There are 4 defects have been pointed out. So, have you removed those defects?
No, sorry, my lord, filed and ungold, so that's some defect also. Actually, direction one time to
Just a minute, let me see that. What are those defects? One is 4. What is that? That's a putty or easy putty. Stamp reporting code is a page code. Adhir Padalam.
This matter also filing in the lower court, ungold high court, so that is the problem, my lord.
So you see that 4A says 15 rupees 50 paisa is payable on the certified copy of the impugned judgment not paid. Photocopy of the certified copy of judgment filed. So you are filing a criminal appeal, you will file a photocopy. That will not do. You regularize the matter.
Yes, my lord.
And then High Court that fee welfare fees of rupees 50 not paid. So you remove all these defects.
Yes,
Then
in 1 week, my lord.
the Land and Council for the verify these defects and remove it. The Land and Council for the appellant submits that he will remove the defects pointed out by the stamp reporter within 1 week. This matter in the week commencing from 7th August 2024.
Item 84.
84 on behalf of Mr. Udit Ranjan Jena taken for 1 week after.
Have you supplied deposition copies?
Yes, ma'am.
Mr. Das? Mel. 84 you have received the deposition? Mel. All right. The Land and Council for the appellant seeks for an adjournment. Give another date. Yes, next.
Item 85.
85 was the
Item 86.
86, my lord, on behalf of Mr. Abhishek Das, my lord, that we have solved the deposition copy to government, my lord, may be taken up next week, my lord.
Yes, Mr. Das.
My lord, yes, all my lord.
Today only solved.
All right. Item 86, the Land and Council for the appellant served the deposition copies of the witnesses to the Land and Council for the state in court today. To seek some time to go through the same. Please this matter. We commencing from 31st July 2023.
Oh, blessed.
Item 87.
My lord, item 87, there is an IFA stay of conviction.
Yes.
My lord, the deposition copies has not been filed. We will file in the course of day, or my lord, within a week.
No, deposition copy I do not require. I have the copy. You supply to the.
My lord.
You must have been having the deposition.
We have not supplied.
All right. Yeah. The Land and Council for the objection affidavit you have filed.
Yes, my lord.
And
It is there in
given the copy.
flag D.
The Land and Council IN number so and so. This is an application for stay of conviction. The Land and Mr. Sanjay Kumar Das, Land and Standing Counsel for the Vigilance Department, has already filed objection affidavit, which is at flag D, giving copy to the Land and Council for the appellant, who seeks some time to file to serve the deposition copies of the witnesses examined in the trial court on the Land and Standing Counsel for the Vigilance Department. List this matter.
Next week, my lord. I pray next week.
No, it will come on 7th August 2020. Yes, next.
Item 88.
My lord, may I please? In last
Item
occasion.
88, may I please, your lords? Lord, item 88, I pray for an adjournment.
No, my lord, in last occasion, there was order in 22/6/2013 to instruction to the appellant, my lord. Order
Let us see that order. Which order you said, Mr. Counsel?
22/6/2023.
Okay. Just let me go through it. The CRL has been filed by Mr. M.K. Mahapatra, Land Council, but Mr. Sujay Shankar Singhdeo, Land Council, has filed Wakalatnama without taking consent from the earlier engaged counsel. That the Land and Trial Court, that is Assistant Session Judge Dharamgarh in city case number so and so, obtain instruction from the appellant as to whom he wants to engage as his counsel. Okay, so a report has come. Yes, at flag C. Flag C, with reference to the subject cited above, I am to submit that the convict, namely so and so, was produced from jail custody on being asked the convict in open court stated that he wants to engage Mr. M.K. Mahapatra, Advocate, High Court of Orissa, Cuttack, as his conducting lawyer. Further, the written consent with regard to the appointment of the advocate of the convict Lakshman Bhati is enclosed. So, Mr. Sujay Shankar Singhdeo, so your the client has said no, you want to engage Mr. M.K. Mahapatra. So, obviously, your wakalatnama will not be accepted.
My lord.
The peruse the report furnished by the Lenin trial court, which indicates that the appellant wants to continue, continue Mr. M.K. Mahapatra, advocate of this court, as his conducting counsel. Huh?
My
In
lord.
view of such report furnished, the name of Mr. Sujay Shankar Singhdeo and his associates shall not be reflected in the cause list. Yes, sir, you can argue the matter.
I'm praying for an adjournment.
All right, Lenin counsel for the appellant seeks for an adjournment. Give adjournment. Yes, next.
Item 89.
89, Mr. Ashit Kumar Jena.
Appeal move has not been filed.
What is this criminal appeal for? Conviction. Yes.
Defects are also there.
20B2C, it's 10 years there. 1 lakh fine. Defect 5D means state copy. So, you have not been served with the copy. And counsel for the state submits that he has not been served with the copy of the appeal memo. Huh? Agurithra. State submits that he has not received the copy of the appeal memo along with so. Oh, on that day also nobody appeared. Ashit Kumar Jena. So his phone number is there. So in the wakalatnama, Mr. Das, his phone is a criminal appeal. I don't want to dismiss it for non-prosecution. Last time also he was not there, but it's a conviction matter. So give him a ring. I will take up this matter after lunch. He's a regular practitioner, I think. So that number you just give him. Yeah. Pass over after lunch.
Item 90.
Mr. Mishra, Sushant Kumar Mishra. All right, pass over then.
Item 91.
Please, Your Lordship. The appellant is challenging the conviction passed by the Learned Assistant Session Judge Bhanjanagar in ST case number 44 of 2015. The convict is sentenced to undergo RI for a term of 2 years for offence under section 324 of IPC and 5 years for offence under section 506 of
This
IPC.
criminal appeal has been admitted or
My lord.
when it was admitted? Hey, the order. देखिए admission है जी सब order उड़ा कर मतलब आनी वो नहीं admit ही नहीं. So how many orders have been passed? Only one. When it was admitted? I asked him you pertinent question whether it has been admitted. You said yes. It's a criminal appeal against conviction. It has come for in the heading of orders. So that is why I asked you. All right, hard admit, call for the trial court record. What is the sentence imposed here?
10 years.
All right, interim applications for bail and stay realization of fine be considered after receipt of the trial court record, and counsel for the appellant shall supply the deposition copies of.
Already I have supplied.
Already supplied.
Deposition copies have been supplied. So matter to be taken up, we commencing from 7th of August 2023.
Item 92.
Lordship, conviction for the offence under section 376D and section 6 of the POCSO Act. The sentence.
It has already been admitted, Mr. Moon.
Yes, Lordship.
What is the date?
This is for bail.
Oh, had admitted. Okay,
The
that has
last
been
occasion-
done on 22/6. You have supplied deposition copies.
Lordship.
Mr. Das, you have
Ma'am.
received the deposition copies.
No, my lord, I have not received.
अच्छी है यहाँ पर रिसीप्ट तो अच्छी आप ऑफिस आने वाली चीजें आप कौन
Please show the receipt so that it can be taken
Madam.
up next week.
Lordship.
We'll take up this matter next week on Monday. The London Council for the appellant submits that deposition copies have already been supplied, filed in the AG office. London Council for the state submit that the same has not been tagged to file, and the matter may be taken up next week. Please, this matter we commencing from 31st July 2023. Yes.
Item 93.
May I please, my lord? This is an application appeal for bail, my lord. Offence under section 363, 366, 376, 2N, along with section 6 of POCSO Act, my lord.
376(3) is there,
Yes, no, 376, 2N.
but in the top it is mentioned as 376(3).
No, my lord. This is 2N.
Yes, let us see that. Where from they got it? 376(3). Yes, it is mentioned in the page 14 of the rejection order.
93 मतलब copy has not been, sir.
Actually, it was filed, BLAPL was filed. It has been converted.
That's a
BLAPL
different matter.
Yes,
I asked you whether the offense under section 376(3) is there or not. Please come to page number 14. That is the rejection order.
Yes, ma'am.
Are you having that?
No, that.
How you will move a bail application? You are not having the brief with you.
Yes, well, I have the brief, but criminal, it has been converted to criminal appeal, so that let it be taken up day after tomorrow, my lord. I will bring that.
The London Council for the state submits that he has not been served with a copy of the criminal appeal memo. Let the London Council for the appellant serve the appeal memo along with the impugned order, along with the annexed document on the Land Council for the state during course of this week. This matter in the week commencing from 7th August 2023. It had actually you have to serve 2 copies, since one of the offenses under section 376(3), 2 copies to be served. One of which shall be written, the other copy will be sent to the concerned police station for service on the informant. Matter to be listed, give a date after 2 weeks. Yes.
Item 94.
My pleasure, Lordship. Paper 1 week after.
1 week after. You have received the copy of the appeal memo?
Against the acquittal.
Oh, what is the offense here?
307 and other. Appellant is informant.
Informant's appeal under 372. So the main offense is under section 307 IPC.
Yes, sir.
Okay, Land Council for the appellant 6 for an adjournment. Yes, next.
Item 95.
May I please, Lordship? My lord, here offences are under section 374, 58, 323, 324, 326, 307, 376, 511, 34 and 75 IPC, section 8 and 11, 4 of the POCSO, my lord. But I have been acquitted from the offenses 376, 511, 75, 34. And rest part, I have been convicted for more than 10 years, for 10 years, my lord. Well, kindly have a glance to the operative part of sentence, my lord. That is page 47, my lord. In other allied offenses, all the offensive punishment will run concurrently. That was the direction of the learned code below, my lord. Here, my lord,
Yes.
fact of the case is like this. The informant, while she was at her residence, sleeping at her residence, at that point of time, these appellants, present appellant, along with another person, went inside to her house and caught her throat. And after that, the FIR was lodged. 7 days after, she was shifted to local hospital. Thereafter, she was shifted to Kaling Hospital, my lord. Here, my lord, the copies of deposition I have served, my lord. The main witnesses are PW1, PW5, and PW6.
No, who is that injured?
Injured is PW6, my lord. And IO is PW17, my lord. Those four are very important. And 3 witnesses were posted. Those are co-villagers, my lord. And other witnesses, either witness and others are there, my lord. Here, my lord, what has happened? In the dark night, when the incident was occurred, the victim has never seen the 2 persons. She stated, I saw a person who looked like Badal. Badal is not the accused here, my lord. Then subsequently, but she has not given statement at that point of time, her throat was cut, and she wrote it down. Subsequently, 7 days after, again she stated, the person to whom I had seen, he looked like Pappu, the present appellant, my lord. And that has not been corroborated. The Pappu was there at the relevant point of time, my lord. There is no material before the Senate code below.
In the paragraph number 2,
yes,
this PW6, the injured,
yes, ma'am.
he has stated that after some time, second page,
Yes, ma'am.
I heard a sound for which I woke up and noticed both the accused persons were standing in front of me.
Yes, ma'am.
While I tried to stand, accused Pappu, means this appellant, closed my mouth by his hand, and co-accused Dhuna dragged me.
Oh, yes, ma'am.
Then accused Dhuna asked me whether I like Pappu or not.
Yes, ma'am.
While I asked in a negative manner, both assaulted me.
Yes.
Pappu asked Dhuna to commit so-and-so rape.
Yes, ma'am.
I did not agree with the proposal. Then so-and-so asked open my shirt. Dhuna asked me to open my shirt, to which I denied, or which I gave a slap. I caught hold of the neck. Accused Dhuna committed so-and-so. My ring finger of left hand showed the injury. The injured Dhuna asked so-and-so to commit murder by cutting the neck as caught hold of my.
Well, thereafter,
So that is there.
Well, may I read another person? The cross examination.
The accused, Radhya.
And the mallet.
Just a minute.
Yes.
The accused Pappu caught hold of my hands from my backside, and accused Dhuna caught my neck by a knife at 3 places, causing bleeding injury. This is the chief examination of the victim, who is a girl aged about 18 years, unmarried, and what you have elicited in the cross examination?
My kindly have a glance to paragraph 7.
And she was treated first in the Niali,
Hospital.
then shifted to SCB Medical College, then to Kalinga Hospital, and then operation was conducted. All these things are there.
My lord,
And
that is
yes,
there, my lord. But whether this Papu has committed the crime, that is the point, vital point to be addressed here.
yeah, she knew you. They say that I know both the accused persons standing in the dock. So both the accused persons.
Co-villagers, my lord. They have.
Yes. So what is the question of identity dispute?
The identity dispute because dark night is the category.
No, dark night is not that you cannot identify even your close persons.
400 meters distance from
by gait, by walking posture, it can be a person can be identified even in darkness. So that is
My
depends.
lord, may I come to my appreciate your lordship, my kindly appreciate. Here, my lord, what is this paragraph 7, my lord? I was conscious state while taken to Niali Hospital. At Niali Hospital, I wrote in a paper about the incident and the names of culprits. I had not mentioned the name of accused, Pappu, in the said paper.
No, in the FIR, your name is not there.
FIR it was there, but subsequently it was incorporated.
Just let me
Initially it was not there.
Wait. FIR code. Trial court record of our not final form. What is the FIR copy? List of exhibits.
And she was also all along bail, my lord. She was also.
Kind of. What is the FIR? FIR is marked as exhibit number.
My lord. Sorry. Where was marked? My lord, exhibit 10. Exhibit 10, my lord.
Have you got a copy of the FIR with you?
Sorry, my lord. Yes, I have. Exhibit 8. What is it? Is that legible, my lord? I have legible, sir. Yeah.
So obviously the other family members didn't know about the names of the culprits because that incident took place in the bedroom of the victim where she was sleeping. And she was found in a bleeding condition. The neck was cut and she was senseless, then shifted to the hospital. So obviously after she regained sense, she gave the names of
My lord, she went to upstairs. After that, she went to upstairs, my lord. She knocked the door of the parents because ତାଙ୍କର ବାହାରୁ କବାଟଟା ଲକ୍ କରିଦେଇଥିଲା ବାପା ମା ଯୋଉ ରୁମ୍ ରହୁଥିଲେ ଆଉ ସାଇଡ୍ ରୁମ୍ ରେ ଜେଜେ ବାପା ବି ଶୋଇଥିଲେ.
It is mentioned in the FIR ମୋର ଝିଅ ବିକଳରେ ଚିତ୍କାର କରିବା ପରେ ରକ୍ତ ଜୁଡୁବୁଡ ଅବସ୍ଥାରେ ଘୁଷୁରି ଉପର ମହଲାକୁ ଯାଇ କବାଟ ଖୋଲିବା ପରେ ଆମ ଘଟଣା ସମ୍ପର୍କରେ ଜାଣି ସାଇ ପଡିଶାଙ୍କୁ ଡାକିଲୁ। ଏହାପରେ ମୋର ସ୍ୱାମୀ पड़ोशी सहायतारे प्रथमे नियाली पीएससी कटक परे भुवनेश्वर कलिंग हॉस्पिटल को नहीं ଯେଉଁଠାରେ पीड़िता चिकित्साधीन रही। So that is how when her statement was recorded for the first time.
First time it was recorded, my lord. I have 161.
When I turn to the evidence of the IO, my lord, para 13,
PW,
17, my lord.
Para 13,
my lord.
Yes.
Middle of the just I'm reading out, my lord.
Yeah.
It is a fact that the statement of the informant has been recorded twice on 4/7/2016 and subsequently on 22/8/2016. It is a fact that PW5 has not stated before me in a statement recording on 4/7.
Here the victim is PW6.
PW6.
Yes.
That they took her to Neari Hospital from where the SCU Katak and then shifted to Kalinga Hospital, BBSR. And while she was undergoing treatment at Neali Hospital, just altered the name of Dhuna repeatedly as one of the author of the crime. While she was undergoing treatment at Kalinga Hospital, as she was unable to speak, she disclosed about the cause of her injury in writing in my presence, and after 7 days of her treatment, she also disclosed that accused person Dhuna and Pappu had entered inside her bedroom, torn her wearing apples, and tried to commit suicide.
So this man was on bail during trial.
Yes, my lord. 2 years initially he was inside the custody, 2 years, some days, few days, my lord. Thereafter he was enlarged on that. That may kindly have a glance to this one judgment copy at page my lord, 15, my lord. Date of arrest was 3rd July 2016 and he was enlarged on bail 24/8/2018.
What about the criminal antecedents?
No antecedent, my lord.
I have to
Yes.
obtain, my lord. It is not.
Antecedent. What is it?
The learned counsel for the state seeks some time to obtain instruction about the criminal antecedent, if any, against the appellant. List this matter in the week commencing from 7th August 2023.
My lord, one more thing, my lord, if you'll also appreciate, my lord, here delay has been condoned, I think, but relation file has not been stayed. Delay has been condoned. 53 delay was there.
No, it has not been admitted. It has
admitted past June, my lord.
Delay condon.
Delay condon.
That's it. Yes.
Obligement. My 8th of June, 7th August.
Item 96.
May I please, your lordship? Here in this case, my lord, delay of 50 days to file this appeal, my lord. And convicted under section 376 376 2N and
54 days delay.
My lord.
It's a case of conviction.
Conviction.
Yes, Mr. Das. IN number.
Custody.
So this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 54 days in filing this criminal appeal. After hearing the learned counsel for both the parties, going through the averments taken in the interim application, and since it's a case of conviction where the London trial court has imposed 10 years of substantive
20
sentence.
years.
20 years. I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit. Call for the trial court record. You have filed interim applications. Interim applications for bail and stay realization of fine be considered after receipt of the trial court record. Deposition copies of the witnesses be supplied to the London Council for the state in the meantime.
Obliged.
Item 97.
I have for condolation of delay minor.
Case of conviction.
For admission.
Conviction.
Yes. Conviction. Conviction.
What is the sentence imposed?
20 years.
20. What is the delay?
Delay of
No idea. 101 day. Sorry. Sorry. Oh, sorry. 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 All right. Same order for the 111 days delay condone. Hard admit. Call for the trial court record. Baki interim applications file karchindi.
Yes.
All right. Interim application to be considered after receipt of the trial court record. Deposition copy to be supplied. All right.
Item 98.
May I please for conviction, my lord, 20 years, my lord, 67 days delay.
Where is that page? Delay. अच्छा नहीं है नहीं तो कर कोडी कोण आपला कागज कोट रखुचन त ठीक थियो ना ए पेज टा कोडा is doing this scanning 33 days na. All right, had IA delay condone same type order admit. You have filed interim applications. All right, delay condone admit, and then there's interim application to be considered after receipt of bill. Yes.
Item 99.
Item 99, may I please, Lordship? Item 99, I am on behalf of Mr. M.K. Mahapatra, my lord. I have filed an IF for modification of order.
What modification?
Modification is the Lordship may produce order dated 3/7/2023.
3/7/23.
Yes, ma'am.
Yes.
Not page number 3.
Where is Mr. Mr. What is that?
My lord, page number 3, my lord.
Page number 3, yes.
Lord, fourth para. Let the appellant petitioner on surrendering be released on bail pending disposal of the appeal on furnishing a bail bond of rupees 50,000 with 2 solvent sureties each for the like amount to the satisfaction of the land trial court. The is disposal. My lord, here the appellant petitioner on surrendering, my lord. But the petitioner is in custody, my lord. And that on surrendering part is to be deleted.
So after pronouncement of the judgment, you are taken into custody.
Yes.
All right, that word is to be
Yes,
deleted.
on surrendering part.
All right, IA number so and so is an application for modification of the order. The London Council for the appellant submits that in the operative portion of the order dated 3/7/2023, passed in IA number 1475 of 2023. The words on surrendering be deleted as the petitioner is already in custody after pronouncement of the judgment. And counsel for the standing counsel for the vigilance department, Mr. Das has no objection, considering the submission made by the land council for the respective parties, the in page 3 of the order dated 3/7/2023, passed in IA number 1475/2023, in the third paragraph, first line, the words "on surrendering" stands deleted. The rest part of the order remain unaltered. IA is disposed of.
Item 100.
That's an item 100. I pray for a passover on behalf of Mr. Panda.
You have received the case diary? All right.
Grateful.
All the Passover matters.
Passover item 17.
17.
Yeah. The bail petitioner charge sheet create under section.
Wait, Mr. Chamberlain. One 155 2022. So, first application.
Again, 19/6.
You have received the case diary?
Yes, ma'am.
What is the custody date?
19/6/2022. 19/6/2022.
Offences under which charge is submitted?
364, 302,
364, 302,
201, 34.
201, 34.
And no direct evidence.
What is the name of the deceased?
This is murder. His name is Attaullah Khan. Husband of the informant.
No direct evidence. Then what are the materials mentioned?
2 days after the alleged missing of the husband of the informant, FIR registered the laws with the allegation that the husband of the informant has illicit relationship with one co-villager, lady Malad. Her name is Olira Begum. And in this process, although it was opposed by the informant, but the husband didn't care for the same and continued the relationship. On a particular date, there was some hitch in a particular public place, where the Olira Begum, the person with whom the present informant husband has relationship, she has threatened that if you will not be of mine, I will not allow to live in the world. I will finish you. So that was a threatening. No specific time period has been there, but that was
by that lady.
By that lady. By that lady. And that was the last cause as has been affected in it. So in the FIR, it has been lollies that on the specific ଜଣାଉଛି ମୋର ସ୍ୱାମୀ ଅତାଉଲ୍ଲା ଖାଁ ସବୁବେଳେ ଆମ୍ଭ ଗ୍ରାମର ଅଲିରା ବେଗମ ଘରକୁ ଯିବା ଆସିବା କରୁଥିଲେ। ମୋର ସ୍ୱାମୀଙ୍କର ଅଲିରା ବେଗମ ସହିତ ଅନୈତିକ ସମ୍ପର୍କ ଥିବାରୁ ମୁଁ ଆଗରୁ ଜାଣିଥିଲି। ତେଣୁ ମୋର ସ୍ୱାମୀଙ୍କୁ ବାରମ୍ବାର କହିବା ପରେ ମୋ କଥା ଶୁଣୁନଥିଲେ। ଆମ ଗ୍ରାମର ସରପଞ୍ଚଙ୍କ କହିବା ପରେ ମୋର ସ୍ୱାମୀ ଅଲିରା ବେଗମ ଘରକୁ ଯିବା ଆସିବା କମାଇ ଦେଇଥିଲା। ଏହାପରେ ପଞ୍ଚାୟତ ଅଫିସରେ ଅଲିରା ବେଗମ ଆମକୁ ଧମକ ଦେଇଥିଲା ଯେ ଅତାଉଲ୍ଲା ଖାଁ ଯଦି ମୋର ନ ହେବ ତେବେ ମୁଁ କାହାର ହବାର ଦେବିନି ଏବଂ ସେ ଭିତରେ ମରିବ। On 16/6/2022 16/6/2022 ଦିନ ସନ୍ଧ୍ୟାରେ 5ଟା ସମୟରେ ଆମ ଗାଁର ରିଙ୍କୁ, ମୋର ସ୍ୱାମୀ ରିଙ୍କୁ ପିଟିସନ ଆଜ୍ଞା ମୋର ସ୍ୱାମୀଙ୍କୁ ଲୋଭ ଦେଖି ତାଙ୍କୁ ଆମ ଘରକୁ ଡାକି ନେଇଥିଲା। ଅଲିରା ବେଗମ ଘରକୁ ନେଇଯାଇଥିଲା। ଗତକାଲି 16/6/2022 ସନ୍ଧ୍ୟା 7ଟା ସମୟରେ ଆମେ ଖବର ପାଇଲୁ ଆମ ଗାଁର
No, so that means you are the person who took the deceased to the house of that lady.
My humble submission, although that is the allegation and it is said by
No, that was on what date? What date?
16 तारीख
16?
16/6/2022
16/6/2022. Okay.
କିନ୍ତୁ କୋଣ ଜାଗାରେ in our statement she has not said that ମୁଁ ଛିଡା ହେଇଥିଲି ନେଇକି ଗଲା ବା ମୁଁ ଦେଖିଲି ନେଇକି ଗଲା ନାହିଁ କେବଳ କହିଲା ମୁଁ ନେଇକି ଗଲା all 3-4% have said that ତାକୁ ନେଇ ଯାଇଥିଲା ବୋଲି but nobody has seen that
Okay. When the dead body was found.
The dead body was found on 17th 17 तारिख ସନ୍ଧ୍ୟା 7ଟା ସମୟରେ
From which place it was?
Nearby that stone quarry, laterite stone quarry wherein some water is there. And this particular and the affair has been lost after that. So on 16/6, this thing was there. On 17/6, dead body was there. 18th affair was lost, my lord. And in the affair, although at the relevant time when the affair was lost, the 7 except missing part is there because he was found missing in the house. But in the affair it has been said that as I have pointed out, ମୋର ରିଙ୍କୁ ମୋର ସ୍ୱାମୀ ଗତକାଲି 17 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟା 7ଟା ସମୟରେ ଆମେ ଖବର ପାଇଲୁ ଆମ ଗାଁର ରିଙ୍କୁ ଅଲିରା ବେଗମ ଦି ଲେଡି ଅଲିରା ବେଗମଙ୍କ ପୁଅ ନବୀନ ଏବଂ ତାର ପୁତୁଲୁ ସମସ୍ତେ ମିଶି ମୋର ସ୍ୱାମୀର ଗଳା କାଟି ହତ୍ୟା କରିଛନ୍ତି ପ୍ରମାଣ ଲୁଚିବାକୁ ଯାଇ ନିଆଳ ନିକଟରେ ଥିବା ଛୋଟ ଗାଡିଆ ପକେଇ ଦେଇଛନ୍ତି. So till 18th there is no confession of that Olira Begum was there. How she has murdered all these things, but in the FIR all things has been mentioned.
No, this FIR was lodged by whom?
By the lady.
That means widow of the deceased.
Okay.
What is her name?
Asma Begum. Asma Begum.
ASAMA Begum.
ASMA Asma.
Asma Begum. That too on you said
2 days after.
18/6. And Asma Begum in his 161 statement said that she had seen the नहीं गला अपना कौन पूछे थे अपन पहले नहीं से जो सांगरे डाकी नहीं गला ना कौन सही लाइन टा पढ़ो
मोर नाम अस्मा बेगम सचिन सच आज 6/9/2022 after about particular day बयान है कि जे मोर स्वामी अबतुल्ला खान पिता सबले आम गांव अलिमा बेगम को जीवर जीवा आसिया करथुर आम घर पाखरे असीमा बेगम घर अछि मोर स्वामी को सेठो जाई अलिमा बेगम सहित अनैतिक संपर्क थिला तेणु मोर स्वामी को बारंबार कहया परे मो कथा सुन नथिले आम गां सरपंच आउ समस्ते कहया परे मोर स्वामी अलिमा बेगम घर को जीवा आसिया कमै दिथिले एहा परे गत 3 मास तळे पंचायत ऑफिस रे अलिमा बेगम आमु धमक देथिला जे अतुल्ला खान जदि मोर न हेबो तेबे मु काहाकू हेबाकू देबिनी एवं से एई भितरे मरिबो गत 16/6/2023 संध्या 5टा हेबो आम गां रिंकू मोर स्वामी को लोभ देखै ताकू आम घरु डाकी नै अलिमा बेगम घर को नेकी जाइतिला गत 31 तारिख दिन गत 17/6
No, what you mean to say that he himself not stating that I saw this only.
That's all. And all 2-3 other witnesses they have also said so, but nobody has said that we have seen.
Okay, and that is one part. That is about the last scene. And I think that this last scene is not mentioned in the FIR also.
Last scene, I guess, last scene says that कोई भी स्थिति थिला या if I take note of that part.
Where it is mentioned last scene.
तो 16/6/2023 संध्या प्राय 6टा रे 5टा बेलू आम घर रिंकू मोर स्वामी को लोभ देखै नै गेला
FIR अछि. Okay, so that is there. All right. So
my humble submission.
Okay.
Because of the fact the FIR has been lost 2 days after. Till that date, ballot, the present petitioner, the other persons, and the son and the nephew of that Olira Begum, none were have been arrested or their statement has been come up. So under what circumstance he got this information that all the
apart from this last scene, what else is there?
Recovery of knife is also from that particular lady.
Mr. Tripathi.
Yes, ma'am.
Last scene was on 16/6/2022.
Yes.
Then what Mr. Chand says that the dead body was found at a different place. That means not in the house of that lady, where according to the prosecution that she took the deceased to the house of that lady with whom the deceased has illicit refer. But the dead body was found in somewhere in near a stone quarry. So and that too on the next day. And no direct evidence is there.
No direct. Last scene theory is there.
Last scene is there that they say that Daki Negola A Goru, Manasiju lady.
Yeah, other statement is also there.
No, ସମସ୍ତେ ସେଇ type ର କହୁଛନ୍ତି।
No. One Farooq Khan.
କଣ ଅଛି କହିଲେ?
ଫାରୁକ ଖାନ କହୁଛି 16/6/22 ତାରିଖ ସନ୍ଧ୍ୟାବେଳେ ରିଙ୍କୁ ଓ ଅତୱାଲା ଖାଁ ଓର ପିଲା ଦୁଇ ଜଣ ରିଙ୍କୁର ଗ୍ଲାମର ମୋଟର ସାଇକେଲରେ ଆସି ମୋ ଦୋକାନରେ ପହଞ୍ଚିଲେ ଓ ଅଣ୍ଡା ଚପ୍ ଖାଇ ପାର୍ସଲ ନେଲେ। ମୁଁ ରିଙ୍କୁକୁ ପଚାରିବାରୁ ସେ କହିଲା ସେ ଦୁହେଁ ପାଇକତିଗିରିଆର ଆଲିମା ବେଗମ ଘରକୁ ଯାଉଛନ୍ତି, ଯେହେତୁ ଆଲିମା ବେଗମ ସହିତ ଅତତଲ ଖାନ ପିଲାର ଅନୈତିକ ସମ୍ପର୍କ ଥିଲା। ମୁଁ ତା କଥାରେ ବିଶ୍ୱାସ କରିଥିଲି, କିନ୍ତୁ ମଝିରେ ପଞ୍ଚାୟତ ଅଫିସରେ ଅଲିମା ବେଗମ ଧମକ ଦେଇଥିଲା, ଅତୱାଲ ଖାନ ଯଦି ତାର ନହବ ତେବେ କାହାରିକୁ ହେବାକୁ ଦେବିନି ଏବଂ ଆ ଭିତରେ ସେ ମରିବ। ପରେ 17 ତାରିଖ ଶୁଣିବାକୁ ପାଇଲି ଆମ ଗାଁର ରିଙ୍କୁ ଓ ଅଲିମା ବେଗମ ଆଲିମା ବେଗମର ପୁତୁରା ମନସୁର ଖାଁ ଅପୁ ଉତୁଲୁ ଅନ୍ୟମାନେ ଅତୁଲ ଖାଁକୁ ଗଳା କାଟି ହତ୍ୟା କରି ପ୍ରମାଣ ଲୁଚିବାକୁ ସବୁକୁ
This statement indicates that he was in the company of the deceased. What is the statement that?
Farooq Khan.
That statement, according to that statement, they were seen in the
together
on 16/6. Any criminal antecedent?
No.
Just let me.
এবং এই স্টেটমেন্টটাকে 8/10/2022 রেকর্ড হয়েছে 4 months after.
One antecedent 379 case.
Or the learned counsel for the petitioner, learned counsel for the state, learned counsel for the petitioner submits that the petitioner is in judicial custody since 19/6/2022 and he has been charged sheeted under section 364, 302, 201 with 34 of the Indian Penal Code. There are no eyewitness to the occurrence. The case is based on circumstantial evidence. The learned counsel further submits that materials on record indicate that the deceased, Ataullah Khan, who is the husband of the informant, was having illicit relationship with a lady of the village, and according to the prosecution case, the petitioner called the deceased on 16/6/2022 and took him to the house of that lady with whom he had illicit relationship in his motorcycle. And on the next day, that is on 17/6/2022, the dead body of the deceased was found in a stone quarry. The land council further submits that in view of the available material on record and the period of detention of the petitioner in judicial custody, the bail application of the petitioner may be favorably considered. Land counsel for the state doesn't dispute that the case is based on circumstantial evidence. He placed the statement of one Farooq Khan, who was stated about the last scene of the petitioner in the company of the deceased Ataullah Khan, and further stated that, and the appellant further stated, the petitioner further stated that he is taking the deceased to the house of the lady with whom he had illicit relationship. And counsel for the state further submit that the petitioner has got one criminal antecedent for the offense under section 379 of the Indian Penal Code. Considering the submission made by the land counsel for the respective parties, nature of accusation against the petitioner, absence of direct evidence, nature of circumstantial evidence on record, And since the only material available against the petitioner is the last scene of the appellant in the company of the deceased, one day prior when the dead body was recovered at Stone Ferry, taking into account the period of detention in judicial custody, I am inclined to release the petitioner on bail allowed, shall not try to tamper with the evidence, appear before the learned trial court on each date when the case would be posted for trial, violation of any terms and condition, surrender, cancellation of bail.
Item 26.
Yes, Mr. Mishra.
May I please, Your Honor? Offense alleged is 498A 302.
Past case
Yes, madam.
or earlier rejected? (26) BLFL 1261 2020. You have received the case diary, Mr. Mahapatra? What is the date of custody?
15/5/22.
Charge sheet under section
498A 300.
name of the deceased?
Irme Madkami.
E.
IRME.
Acha. IRME. Madkami. How the petitioner is related to the deceased?
Husband.
Date of marriage?
It is stated 6 months before the occurrence. Occurrence is 12/5.
Cause of death?
Cause of death, opinion reserved. And allegation is case of poison.
That FSL report didn't come?
No.
Final opinion not. So, what are the injuries sustained?
No injury sustained. I have given the charge sheet, post-mortem report. Your Lordship may kindly see.
How did you find out it is a case under 302 IPC?
No, my lord, that has not been only basing on the statement of Bhima Madkami, my lord, prior to the occurrence night, the victim, the deceased my lord, had gone to Bhima Madkami's house, neighbor's house, saying that he is there is a dispute Kondola with my husband. She stayed in neighbor's house for the entire night, came in the morning, and early in the morning she returned to the house of the petitioner, and found at 11 a.m. my lord, he found near the tamarind tea outside the house of the petitioner
No,
in unconscious. That is nearer, my lord, that is in unconscious state. And Bhima Madkami and another witness, well, they saw the foam coming from his mouth, and organ phosphorus poison smell is coming. Basing on that, he filed the no final opinion on the chemical examination report.
No, you are submitting charge sheet under 302 IPC.
Yes, basing on that statement, my lord, he filed charge.
Because poisoning case, there is no injury.
No.
So it may be also suicidal. It may be accidental. Somebody.
Yes, that opinion has not been.
How did you file charge sheet under 302? Heard the learned counsel for the petitioner and counsel for the state. And counsel for the petitioner submitted that the petitioner is in judicial custody since 15/5/2022. He has been charge sheeted under section 498A 302 of the Indian Penal Code. The petitioner is the husband of the deceased, Irma Madkami, and their marriage was solemnized 6 months prior to the date of occurrence. which took place on 12/5/2022. It is submitted that though it is suspected to be a case of poisoning, but no final opinion has been received in that respect to file a to show that it's a case of homicidal death. And therefore, the submission of charge sheet under section 302 IPC is totally misconceived. The Land Council further submits that in the post-mortem report, the doctor has not noticed any injury on the person of the deceased. And therefore, there is no clinching material against the petitioner relating to his involvement in the crime. And in view of the period of detention in judicial custody, the bail application may be favorably considered stopped. And counsel for the state, on the other hand, submitted that there was some dispute between the petitioner and the deceased, and the deceased stayed in the neighbor's house.
Bhima Markami.
Bhima
Bhima
Markami on the previous day of the occurrence.
Yes.
And on the date of occurrence, she was found in an unconscious state under a tamarind tree. And growth was coming out from his mouth, and then she was shifted to the hospital where she was declared dead. Land Council also submits that no FSL report has been received. Considering the submission made by the Land Council for the respective parties, the nature of accusation against the petitioner, the surrounding circumstances under which death of the deceased has taken place, absence of any clinching material to show that it's a case under section 302 of the Indian Penal Code, and further taking into account the period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed. Yes.
Item 31.
Yes, Mr. Pradhan.
Yes. Your present petitioner
Yes, Mr.
is in
Naik.
custody since 6/3/2018. But yesterday I placed the order of the Honorable Supreme Court where my Lakhan Soni.
Where is that order, please? From yesterday. Mr. Naik, yesterday this matter was placed,
Yes,
and
sir.
Mr. Pradhan placed the bail order of co-accused Lakhan Soni. According to him, the petitioner is similarly situated, and the petitioner has remained in custody for a longer period than that Lakshman Soni, who has also criminal antecedents. So he's claiming parity with that Lakshman Soni. And what is your submission to that?
Lordships, I have read several judgments of your lordships, where your lordships have held that parity is only
is not a
one of the
sole
ground. It is not the sole
Yes.
ground, and he cannot claim Article 14
Yeah.
on parity if his roles are different.
Okay.
And just because, and if your lordships will see the Supreme Court order, I have read the Supreme Court order last night.
Yes.
Actually, the Supreme Court order only speaks about the delay.
Period of detention has been taken into account. It is in that order. It is mentioned that
It is obvious that it could not be said. It could not be said that when the examination of the witnesses would be over.
No, it is mentioned the first in the first page. It is mentioned about the date of arrest to be 4/2/2019.
Yes, your lordships.
And then it is mentioned that 22 witnesses have been examined.
And it could not be said.
But there are 164 witnesses, and it could not be said. Yes, now you place, yes.
It could not be said that when the examination of the witnesses would be over, taking note of the law incarnation, we are of the view that appellant can be released on bail subject to the terms and conditions. So basically, Your Lordship, the merits of the case were not discussed. It was only on the basis of the law.
Right. Only on the he also says that I have detained for more than the Lakshan Soni. So how
Your
do
Lordship,
you
there is a difference between Lakhan Soni and him. Before that, Your Lordship may kindly come to page 26 of the charge sheet of the paper book.
Charge sheet, page 26. 26 Bhargava.
It starts, Your Lordships, brief facts of the case, if Your Lordships will see.
Yes.
May I proceed?
Yes, proceed.
Your Lordship, this case is an offshoot of that Subrat Chaturaj case, if Your Lordship will remember. The total collection of the company, Your Lordships, is 431 crores, 43 lakhs, 98,444 rupees. My respectful submission before the Honorable Court is that, Your Lordships, the amount of money which is transformed to the personal account of all the accused persons is a very limited amount, Your Lordships. They all are the joint custodian of the entire amount. Just because a portion of that amount has been transferred to each account, that doesn't make them liable only for that amount, is my respectful submission before you, Lordships. Because, Your Lordships, the amount is 400 crores. The amount which is transferred to each people's account is around 15-20 crores, Your Lordships. Then what happened to the remaining amount, Your Lordships? Therefore, Your Lordships, they all are the joint custodian of the entire amount, out of which a single pie was distributed between several people. Now, if Your Lordships will see his role starts in page 27. He's the main man, Your Lordships. Sri Abhishek Singh Chauhan, page 27, name of the accused and the designations are there.
This man's name is?
Sri Abhishek Singh Chauhan.
Okay. Underline.
Your Lordships, the certificate which was given by them, the certificate says that the accused was never before this Honorable Court.
Just a minute. No, that should not be there. The second one, only first. Just a minute. Yeah, you want to point out from the cost title?
No, Your Lordships, page 27. Lordships, the page 27 of the charge sheet.
No, you said that never before this court. What does it mean?
The certificate they have given, Your Lordships?
Yes.
The certificate says that the petitioner was never before this Honorable Court.
Right.
But, Your Lordships, yesterday from 2017, I tried to find out from the Orissa High Court website, a bail application came 4904 of 2018, which was shown as nature of disposal contested withdrawn. So it seems that it was argued for a considerable amount of time when Your Lordship was not willing to grant bail. They had
Abhishek Singh Chauhan.
No, I have filed memo to that effect. I have filed memo on 21/2/2023 before listing.
So memo was after
there.
Yes, I have filed a memo along with this bail application. Your Lordship kindly see. I have filed memo on 21/2/2023, indicating that by order dated 27/2018, prayer for withdrawal of bail appeal has been allowed. I have given that certificate. Inadvertently, it was mentioned in the bail application never for this code. I have given that memo already.
After I pointed out, it was filed.
My friend has received it on 21/2/2023.
Yes, after I pointed out, you gave me. I have received.
No, sorry, sir. It was not listed.
All right.
Just
a minute. Memo filed indicating that it was earlier withdrawn.
Yes.
Right.
Yes.
Where is that memo?
That matter, I have filed it on 21/2/2023.
Okay, this memo, you underlined it, this memo. Okay. Yes, now you proceed, Mr. Nayak. You proceed, you are proceeding, you are showing me the part in that, that he is the main actor.
Page 27.
27, come to page 27.
Abhishek Singh Chauhan was the
Yes.
CMD of the Nirmal group of company, your lordships.
Okay.
So he was the main man, your lordships. And if your lordships will come to column 5, which speaks about Lakhan Soni,
Lakhan Soni is the head of accounts. Okay.
is the head of the accounts of Nirmal group. Now, your lordships, the role of Abhishek Singh Chauhan starts from page 31.
Just a minute. 27, then 31. Come to 31. Yes.
If your lordships will come to page 31, the role of Lordship may kindly read Abhishek Singh Chauhan. Investigation revealed that Your Lordship, there are 5 columns which starts with page 32. Lordship may kindly.
7 you are placing.
Yes, Your Lordships. There are 5 paragraph 7. There are 5 sub-points.
A, B, C,
Abhishek
D.
Singh Chauhan was the chairman cum managing director of Nirmal Group of Companies. He played key role in the collection of deposits from the investors in the guise of issuance of debentures and getting allotted with plots in future plus land booking deal.
Yes. Yes, Mr. Naik. That please unmute yourself.
And therefore indulged in money circulation business. As the chairman cum managing director, he was one of the authorized signatories. Your Lordship may note it. He was the signatory. Under his signature, everybody got money. That point may be noted, Your Lordships. To operate the bank account of the company maintained with various bank along with director Harish Sharma. This Harish Sharma, Your Lordships, is accused number 2. So, Your Lordship, this misappropriation which he did, there is a single misappropriation which he did himself. There is another misappropriation where he jointly looted money with Harish Sharma. Therefore, it is necessary, Your Lordship, I'll read A2 also. He had conducted several meetings at various places, including Odisha, Balangir, etc., with an assurance of high return of 10%, 19.63%. Now, Lordship, these companies never got any permission from SEBI or RBI to conduct these kind of businesses. Therefore, he used to make promise that you give me money to the poor innocent depositors and I am going to return it more than the banking rate, 20% interest per annum. And the hard-earned money of poor investors, Your Lordships, there are several people, Your Lordships, who belong to the very lowest strata of the society, including rickshaw pullers. They took away 400 crore rupees and he was the signatory and they started distributing among themselves. Huge amount were withdrawn by him from the account of Nirmal Marketing Concept Private Limited, Nirmal Infra Home.
Where is that role of that man who has been released?
No, before that, Your Lordships, may kindly also read Harish Sharma, because Abhishek Singh Chauhan, Your Lordship, may kindly come to page 33, the role of Harish Sharma also.
Number 2.
Harish
Sharma is an bail petitioner here.
No, Your Lordship, Harish Sharma is another accused.
No, why are you showing that, Harish Sharma?
Yes, Your Lordship, I am showing it because of a reason. If Your Lordship will read paragraph 4, huge amount of withdrawn by paragraph 4 of Harish Sharma.
Yeah.
The objective we are showing it, Your Lordship's huge amount of withdrawn by him from account of Nirmal companies and then misappropriated. He also misappropriated 1 crore 46 lakhs something individually. He has also misappropriated other amounts jointly with Director C. Abhishek Chauhan in conspiracy as shown in table. So, Your Lordships, apart from his role individually, he also entered into a criminal conspiracy with Harish Sharma and misappropriated huge amount of money. Now, Your Lordship, may kindly come to Lakhan Soni.
Page number?
Page 35.
35.
Lakhan Soni was the account head of Nirmal companies. He had conducted meetings. Huge amount of withdrawn from him on the accounts of NICL Limited, such and such. This is his limited role, Your Lordships. He was not a signatory, Your Lordships. Whereas he is the owner of the company, CMD. And with due respect, Your Lordship, there was a judicial order that he has to file his criminal antecedents. Just because in the meantime a Supreme Court has passed some order of a co-accused who is on a different footing, that doesn't, with due respect, nullify Your Lordship's order.
Where that order was passed?
Last order of Your Lordships. In the bail application, if Your Lordships will read Abhishek Chauhan's last order.
Oh, I see.
So once Your Lordships has passed a judicial order to file the criminal antecedents.
Just a minute, let me see that. Learned counsel for the petitioner shall obtain instruction about the cases pending against the petitioner in other states, so also in Odisha, and file an affidavit to that effect, giving copy to the Land and Special Public Prosecutor for CBI. Mr. Pradhan,
Yes,
have you
yesterday I had supplied the order of the Honorable Supreme Court.
No, that you have supplied, that's all right.
No, that this is another order I had supplied because this petition had approved the Honorable Supreme Court for clubbing the case. The Honorable Supreme Court has statewise clubbed the case, and yesterday I had given that order.
No, that was clubbing means in Odisha cases were clubbed together.
No, all over India.
No. In each state,
yes,
there are number of cases.
Were there.
So that means, let us say West Bengal, there are 5 cases. So 5 became 1 by
yes,
clubbing up.
Yes, that is the order of the Honorable Supreme.
That is there. So in Odisha also 1 case.
1 case.
So that order copy you have not received, Mr.
Yes,
Nayak?
Yesterday I had supplied the copy of that order.
Yes, Your Lordship, yesterday.
So those case numbers are there mentioned, and the order has been passed to club up. In Odisha now, only 1 case because of that clubbing order. So 1 trial would be there for number of cases.
Yes.
So that's a different matter. But Mr. Pradhan, he is distinguishing your case. The period of detention is something different. But he is saying that your role is totally different than the person who has been granted bail. What is your answer to that?
But so far as present petitioner is concerned,
Yeah.
admittedly he is the managing director.
Right.
But so far as financial part is concerned, the Lakhan
He's
Soni is the
just an accountant or something.
Yes,
like
he is the accountant. Number 1.
Yeah.
Number 2, Your Lordship can see last order. In my brief, I had also supplied the order of this Honorable Court in respect of 1 director also. That order I have given annexure 4. One of the director has already been granted bail by this Honorable Court under annexure 4. Your Lordship kindly see. This order dated 4/12/2021. Since one of the director has been granted bail and one of the accountant has been granted bail by the Honorable Court, and Honorable Supreme Court has said on the ground of delay in trial. Honorable Supreme Court has exercised power on the ground of delay in trial, and the very similar circumstance. But I am not on merit also.
No.
With due respect,
just a minute. Why there was I think there was an order that have I dealt this matter earlier?
Yes, Your Lordships are dealt.
Oh, I thought that why it is coming to me, because now the order is that whosoever has which judge has the first one, it has to go all the matters to him. If it is so the first one is disposed of by me, that withdrawal order.
Yes, I think so.
Okay.
I think so.
That Your Lordship, we have to check.
That
Your Lordship, we have to
Have
check.
you got
Because,
that copy of that order?
Your Lordship, there were 6 co-accused.
No. About this particular petitioner, he has filed a memo and giving the case number. What is the case number?
BLFL 4904 of 2018.
ऐसे बाहर करो देखिए.
Contested disposed लिखो उसका तरह.
Just let
I
me
saw it
see
last
that.
night, Your Lordships.
No, that has not come. Let him see that whether it is available in the High Court website, which honorable judge has disposed it of.
Your Lordships had already disposed it of. I saw it last night.
Okay. All right, then it's all right. Then I have to take up this matter. If you are verified, I need not check it once again. All right. Close
For
it.
abundant caution, it can be checked again, Your Lordship. But if I remember,
Okay. Check once again. BLAPL. That number is 4904 2018. That is disposed of by me. Right.
Contested disposed of.
Is it a withdrawal order or that order has not been uploaded? Oh, withdrawn. Right. It is withdrawn. So obviously I have to take the. Okay. Now,
The
yes,
only
Mr.
question, my lord, kindly bear with me. The stake of Odisha is only 2 crore summer.
Mhm.
With other states are so many criminal cases are there. I will face consequences. There are absolutely no difficulties. So far, Odisha is concerned, stake is only 2 crore summer, and I am in custody more than 5 years.
Where from you got it?
That is in the CD itself. From the charge sheet itself is there.
That figure has been no. Show
That
me
where
that
the charge sheet they have
charge sheet.
reflected.
Show that figure there.
Well, kindly see page 41.
41.
Yes, page 41. Let's
Come to 41.
41. Kindly see C.
Wait. Yes, 41 I have.
Yes, last 2 lines.
Yeah.
Further, with regard to Odisha state, an amount of 2 crore 70 lakhs 95,090 was refundable in respect of 3 branches of finance in Odisha. Even though in the above, the server data further revealed that the total outstanding amount is 430 crore. With so far as Odisha is concerned, 2 crore 70 lakhs. That is the admitted case of the prosecution. He cannot deny that Odisha is concerned only 2 crore 70 lakhs is there. Everywhere they have mentioned in page 40 also they have mentioned 2 crore 70 lakhs.
So now you are in custody since when?
18.
Lordship, kindly come to page 31 for a moment.
Custody since 6/3/2018.
Lordship, kindly come to.
I'll come. How many? What is the total number of charge sheet witnesses?
But 164 charge sheeted witnesses.
How many of them have been examined?
Only 22 witnesses have been examined.
Okay. Yes, Mr. Naik, what do you say?
Your Lordship, may kindly come to page 31.
31.
Yes.
Come.
Final amount of misappropriation as per the second charge sheet.
No, perhaps it has been total money.
Total after 14, Your Lordship, there are 8 zeros. 1, 2.
No,
3.
that is correct, but it is taken into account the in different states. Not so far as Odisha is concerned. That is specifically pointing out from that particular paragraph.
Your Lordship, that is the first charge sheet or second charge sheet. We have to find out.
No, this particular charge sheet which has been filed here, that is dated 17/7/2020. And in this page 41, that amount has been mentioned. Page 41, C.
Anyways, Your Lordships, as a CFD is responsible for the collection of the entire amount all over India and also in Odisha.
And then with that charge sheet, the investigation has been closed because there is nothing mentioned that the investigation has been kept open thereafter. This charge sheet, which has been annexed to as Annexure 1, the last page is 45-46. There it indicates that it is closed. So that will be the final figure.
Yes, but this amount was the amount which was refundable.
And 1, 2. You can come to page 45. 45 also, that figure which Mr. Pradhan was pointing, that is also mentioned there. That 2 lakh something.
2,70,000.
Further, they cheated the public to the tune of rupees so and so and misappropriated the same of so and so. Okay, paragraph number 8. From the materials emerged during investigation. Come to paragraph 8, page 44.
That I've seen, Your Lordships.
they collected money from public with dishonest and fraudulent intention, alluring them of higher returns through the companies, namely so to the tune of rupees so throughout India, out of which, 8 lakh, out of which, so clear it, 2,70,000 in respect of the depositors of this. So 2 crores, 2 crores 70 lakhs.
Now, if all the cases are clubbed together, your lordships,
No, club means Odisha cases have been clubbed together. In Odisha, this amount is 2 crores 70.
now your lordships, now your lordships are granted interim bail to one of the directors, and that director, your lordships, his name is Phul Singh. That is not mentioned in the petition, your lordships. Your lordships had granted him interim bail under the pretext of the daughter's illness. But after getting interim bail, your lordship, that person had absconded.
Who is that man?
That man, your lordship, Phul Singh, is accused number 6.
Oh, I see.
I don't know why that was not mentioned. Your lordship, the Phul Singh, the director, he had got interim bail. Your lordships had only granted, I think, for 3 months. That order, your lordships, I could not find out. But I've been told that your lordships had given him bail and Jio Deho Kharab
What about the this man is an outsider?
Yes, your lordships, he's an outsider. And one more thing, your lordships, which my learned brother forgot to point out. Supreme Court had granted bail to this Lakhan Soni, your lordship, which is not on similar footing. But the same Supreme Court had rejected the bail application of Ashish Chauhan, which is SLP number 2339 of 2019. I don't know after
this address is correct, Mr. Address furnished in the cost title.
This address, your lordships.
Please verify. Otherwise, sometimes that is why outsiders we used to verify that whether on the basis of their statement without verification of the documents, they used to mention it in the charge sheet, and accordingly, in the some cases, it has been found that the address furnished in the cost title is not a correct one. So that if you say that your CBI people has verified it, well and good. There is no problem in that.
I'll find out, your lordships.
Better you find out. We'll take up this matter on Monday. So
Monday
or Tuesday we will take up.
Tuesday, your lordships.
Tuesday. Okay. Mr. Pradhan, what he says that another accused, the Ashish Chauhan, that order you are having that.
So what is
please share it with Mr. Pradhan so that let him go
bail
through.
application has been rejected in the year 2019. What is making that submission?
Please file that order, Mr. Pradhan.
Bail
Mr.
application
Naik.
was rejected in 2019, and the order stands good till today, your lordships, because it has not been renewed or no case has been filed by him.
No, it's all right. Please give that case order copy to me and also to share it with Mr. Pradhan.
The SLP.
Just find out, give it, send it. The Land Council are the Mr. Pradhan, Land Council for the petitioner, and Mr. Sarthak Naik, Land Special Public Prosecutor for the CBI. During course of argument, though Mr. Pradhan raised contention regarding claim of parity with co-accused Lakhan Soni, who has been granted bail by the Honorable Supreme Court in Criminal Appeal number 2060 of 2023 by order dated 21/7/2023. But Mr. Naik pointed out from the charge sheet in page number 27, 31, and 41 that the petitioner is not similarly situated like the co-accused Lakhan Soni, who has been granted bail. Learned Counsel, when a query is made to the Learned Special Public Prosecutor as to whether the address furnished by the petitioner in the cause title is correct one or not, he seeks some time to verify such aspect. He further submits that one co-accused, namely, what is the name that man, Mr.
Ashish Chauhan.
Ashish Chauhan, who is also one of the director, approached the Honorable Supreme Court for bail, and his bail application has been rejected, and he will file the copy of the order and supply the same to the Land Council for the petitioner.
Your Lordship, I think the copy is already with the counsel for the petitioner because he pointed out it is 2019, which I didn't point out.
You are having that copy?
No,
he just catch the year from you and said like that. Don't catch the word. Once you catch the word, he said that it is available with you. You just
SLP number such and such in the year
so
2019.
that is how you catch the word. He said that he is available with you.
No, I have.
All right. So supplying. So matter to be listed on 1st of August 2023.
And the similarly placed accused, I have given that order. The one of the director has been granted bail. Whether they have approved the SLP.
At this stage, Mr. Pradhan submits that one of the director, namely, where is that order?
Annexure 4. Prabal Pratap Singh Yadav.
What?
Annexure 4.
Annexure 4.
Is page 184.
What is that?
My brief, Annexure 4.
Okay, just a minute. One Prabal Pratap Singh Yadav, who is also one of the directors of the company, has been released on bail by this court in BLAPL number 9441 of 2019 by order dated 4/1/2021. The Learned Council Special Public Prosecutor shall obtain instruction as to whether CBI has moved the Honorable Supreme Court against the order of granting bail to the said director.
Lordship may also point out this Phul Singh A6. He was granted interim bail and he absconded.
The Learned Council for the Special Public Prosecutor submits submission submit that one of the co-accused, namely, what is his name, Mr.
Phul Singh A6. Phul Singh Chaudhary.
Phul Singh Chaudhary.
Phul Singh
PHOOL.
This accused number 6 is Phul Singh Chaudhary, who has been released on interim bail by this court, has not surrendered after availing the same. Just take note of it and then you place it on 1st of August 2023. All right. Rest of the matter after lunch.
Your Lordship's next matter is a CBI matter, Your Lordships.
Which one?
Your Lordship, next matter.
T2.
Yeah. Your Lordship, I have some difficulty after lunch. Can it be taken next week, Your Lordships?
No, where is the Learned Council? He was. Yes, sir. So you are there in item 32. So it will be taken off next week. He is having some difficulty. All right. It will also be listed on 1/8/2023. Okay. Keep this order sheet.
May I pray your Lordship, my lord, after recess.
Item 43.
is at page 31.
Yes.
The appellant along with others found guilty.
Yes. What is the sentence?
10 years for 395. Along with other offenses, higher offense 10 years at punishment.
395.
Yes,
Okay. So you are on bail during trial?
yes, sir. PW 7, 18, 15.
Yeah, trial court record. Have you supplied deposition copies?
Yes, sir. Yes, sir. I have supplied. But page, internal page, 2, page 12.
No, FIR
is unknown.
unknown.
Yes, sir.
Date of FIR.
The 6/6/15 minute.
Then any TI period was conducted?
Yes, sir.
So who identified you in TI period?
Informant,
PW
just a minute. Informant is PW 15.
Only one witness.
3 witness, PW 7, 18, 15 minute.
No, 3 witnesses identified you in TI period.
No, 7 and 8 identified, 15 minute denied minute.
No,
Informant
first tell me TI period was conducted.
Yes, sir.
And these 3 persons participated.
Yes, sir.
And all of them in the TI period identified you.
Yes, sir.
Okay. So they are PW?
PW
7,
7, 8 and 15.
7, 8 and 15. Okay. So identified in TI period. Out of them, who identified you in court during trial?
Court PW 7 and 8 minute.
Okay.
And 15 informant denied minute. I do not know accused person standing in the dock minute.
So he didn't support it. Okay.
His her cross minute.
Which cross?
Her cross minute. The informant.
PW 15.
Yes, minute.
Which paragraph?
Paragraph 9 in the cross minute.
Paragraph 9 things. କଣ କରୁଛ ସବୁ?
PW 15 paragraph 9 cross
not
to divide the fields.
Scanning in is a paste. Flag मारिए दिया. Whatever difficulty every day you are facing, ये page 9 से page 9 हमको नहीं एवढा सब तांग notice को आणुछ ना नहीं.
Paragraph 9.
हाँ.
Cross examination by the defense jointly for all.
जो section ने scan होची ताकू जणा एवढा ठीक से होनी बेलु हैला. तमे करूना मु जानि छी बट जी भी करूची ताकू intimation दबा कत. हाँ. So pass on the
Yes.
Who are the other two, this PW 7 and 8?
8 is the husband, 7 is the father-in-law.
Yes, Mr. Misra.
Yes,
Very
my lord.
damaging statement he has given.
Your
against
Lordship
the
may kindly
person.
see para 7, my
Para 7.
para 7
Of this
PW
PW
15. Yes.
Yes.
After some days, the police had called me, my husband and my father-in-law thrice to the sub-jail Khurda to participate in TI parade of the suspect. Accordingly, I had come to the said jail and in presence of the magistrate, I had identified some suspects, but now I am unable to recollect the same.
That is for TI parade.
Yes.
But what happened prior to that? That is in paragraph number 9. Prior to TI parade,
yes,
they were called to the police station. The accused persons were there. They were shown to the accused persons. Then what is the purpose of sanctity of TI parade? If you show the culprits to the after their arrest, if you show to the identifying witnesses, then what is the sanctity of TI parade? That is your prosecution witness number 15 has stated.
15,
he is also a family member. She is also a family member. And she is the informant.
Yes.
She has not been declared hostile.
No.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner was on bail during trial, and there is no material that he has misutilized his liberty. It is argued that the FIR was lodged on 16/6/2015.
5/6.
5/6/2015 against unknown persons. And during course of investigation, the petitioner was taken into custody and he was identified in the TI parade by PW 7, PW 8 and PW 15. PW 15 is the informant in the case and PW 7 is her father-in-law and PW 8 is her husband. And during trial, PW 15 failed to identify the petitioner. However, PW 7 and 8 identified the petitioner. Learned counsel for the petitioner drew the attention of this court to paragraph 9 of the evidence of PW 15, wherein she has stated that when the police got hold of some culprits and detained them in the police station, she was called to the police station and police showed the culprits to her, her husband, bracket PW 8, and her father-in-law, bracket PW 7. And further stated that as per the direction of the police, they identified the culprits in the sub-jail Khurda. The learned counsel for the petitioner submits that in view of the evidence of the informant PW15, who has not been declared hostile by the prosecution, the evidence of identification by PW7 and 8 in court, so also the identification of all the three in trial in the TI period has got no evidentiary value, as the TI period has lost its sanctity in view of the conduct of the police in suing the culprits to the identifying witness prior to the TI period. The Land Council further submits that the petitioner has good chances of success in the appeal and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land Council for the state, on the other hand, oppose the prayer for bail and place the evidence of PW7, 8 and PW15. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced by PW15 in the cross-examination, and since the petitioner was on bail during trial, and there is no material that he has misutilized his liberty, and taking into account absence of any chance of early hearing of the appeal in the near future, I am inclined to release the petitioner on bail allowed. Mr. Raut, you give this PW15 evidence. Keep it whole evidence tonight. You page টা নেই কি দেখো জেরক্স করে এই জায়গায় সাবমিট করে বুঝি পারলো সেটা এভিডেন্সটা নিয়ে এসো Yes, call the next matter.
Item 54.
Mr. Kuntia, Honda, you will argue.
Yes, my
What is the
powder
offense here?
My lord,
What is the offense under which you have convicted?
my page 42 of the judgment, page 55 of the brief,
Running page 55.
55 of the brief, page
55
42 of the Planet Trial Court judgment.
Wait. Sentenced to undergo RI for 10 years.
My lord,
Fine is 3,000. In default to undergo rigorous imprisonment for 6 months under section 304 part 2. Okay. Then 458 by 34. So that is 7 years. Then 3 years 1,201. Then 6 months under 323. 3 years under 506. Sentences to run concurrently. So it's a 10 years is the maximum. So 65.
the petitioners were in custody since 12/11/2018. 12/11/2018.
4 years 8 months ago.
My lord,
4 years 9 months already. What is the name of the deceased?
name of the deceased Malati Pidika.
Malati?
Pidika.
Okay. Doctor is?
Doctor has not been examined.
PM
because
report
the
has been marked as exhibit.
My lord, the PM report has not, but the dead body was cremated.
The dead body was cremated, my.
Was it? Eyewitnesses are there.
Yes.
sir.
Tell me the eyewitness.
Schedule 1, 2, 3.
No,
and-
let us see one eyewitness. PW1 Bhargava.
Schedule 1 informant.
Please read it.
My lord.
Paragraph number 2.
2. The occurrence of this case took place about 4 years back. On the relevant day in the night when myself and my deceased husband were asleep in our house, the accused persons Tadingi, Duburi, Hudki, Tamaya, Pidki Jumbi, and
No.
Pidki Sam.
Petitioner na kono? Petitioner na ile kohibe.
Todingi
Todingi Dumburi.
Dunguri.
How many persons are there in this appeal?
In the appeal, 4 persons, all there, all are.
All of them. Okay.
All.
Entered into our house. Okay, read it.
And dragged my husband out of our house and assaulted my husband by means of thenga in front of our house. The accused persons assaulted to the chest, back, neck, and other parts of my deceased husband, for which there was vomiting of blood. Due to the assault of my deceased husband, fell down on the ground in unconscious condition. The sons of my brother took my husband to my house. On the next day morning, my husband died. On the next day of death of my husband, on the third day, the dead body of my husband was cremated by the accused persons in the burial place of our village. One Ashok Patnaik of Naran Patna scribed the affair as per my instruction. The contents of the affair was also read over and explained to me. I put my LTI thereon. I lodged report after 6 days of occurrence. As I was alone, I could not lodge the report immediately.
So he was declared hostile.
Declared hostile, and he has stated it is a fact. It is a fact that I have stated before the police that.
No, it's all right. In the cross-examination, what you have elicited? Cross-examination, he has, so far as the assault part is concerned, he has stated about the same.
Yes.
And also about the cremation part.
Cremation part. Paragraph 6, my lord. Once Senaka Rao Pidika had called the meeting, it is a fact that as the meeting was being convened at the instance of Shankar Rao Pidika, my husband was called to the meeting place. said Sankara Pidika was the headman of their village. The accused persons assaulted my husband on the village and in front of my house, which was the meeting place. As soon as my husband was taken to the meeting place, he was assaulted. We had slept in our house after returning from our relative. Had stayed near the meeting. After assaulting, we shifted to our house. The meeting was closed as soon as we entered. We had not shifted my husband to hospital. As my husband discovered that it was his last moment of sleep, he has also told not to take him to hospital, for which he did not shift him to hospital. I had also taken liquor on the date of occurrence. I had taken liquor in our village. The deceased was also taken liquor, Pidol 4, as per evidence of Pidol 4, Para 4. And he was not well.
That is also the evidence of the other eyewitnesses.
Yes,
Yes.
yes, similar type. Pidol 4.
And
cross
PW3, you'll also may see PW3 para 2, he has stated categorically that I was present in the meeting, the accused person Tanmaya and Dumburi. They dragged out the deceased from his house and brought him to the meeting place. The meeting was being convened in the middle of our village in front of the house of Dalaya Pidika and Narendra Pidika. The accused persons Tanmaya Dumburi assaulted the deceased by means of bamboo lathi, for which blood came out from his mouth. The deceased also passed tool. I do not know anything more.
So this one stated that two persons assaulted by bamboo lathi. Two persons dragged them. Who dragged them out? That Tanmaya and Dumburi. Tanmaya
and Dumburi.
Dumburi.
But
Dumburi.
Dumburi.
And those two persons also assaulted.
Those two persons also assaulted along with others also.
Others कोटी कहुଛି
ସେ କହୁନି କିନ୍ତୁ PW1 and other witnesses, PW3 and others, they are also stating clearly that all the accused persons, petitioners, they assaulted the deceased by means of bamboo lathi.
PW1.
PW1.
Let us see that line again.
Accused person,
starting so and so entered into our house, dragged my husband, so and so, assaulted them. So is it not the evidence of PW1 and PW3 are not contradictory? If one says that four persons entered house and dragged my husband, and as all the four assaulted by means of thenga, whereas PW3 stated that only two persons dragged the deceased and those two assaulted the deceased. So is it not contradictory?
That dragging part is different and the assaulting part is different.
What?
Two persons dragged from the
Two
house.
persons dragged and those two persons assaulted, as for PW3's evidence. Whereas PW1 has stated four persons dragged and four persons assaulted. So which is correct? They are the eyewitnesses to the occurrence. Court is relying on their evidence. If they are the eyewitnesses, it is telling different story. How many persons actually dragged? How many persons participated in the assault? Can it be said that they are reliable witnesses, truthful witnesses?
No.
And you are to
PW1, 2, 3, and 8. They all are eyewitnesses and they have categorically stated that they dragged all the accused persons. They dragged.
You just now placed the evidence of PW3.
Yes, sir.
PW3's evidence that two persons, he is totally silent about the other two persons' participation. Come to PW3's evidence once again. You just placed the evidence of PW3, right?
Yes, sir.
Come to that portion. PW3
The
come.
occurrence of this case took place about 4 years back.
Right.
One day in the night, a meeting was convened in our village
Right.
on a Sunday.
Go slowly then.
on a Sunday in the night on the allegation of witchcraft.
Witchcraft, right?
I was present in the meeting.
Stop.
The
Accused persons? Who?
accused persons, Tanmay and Dumburi,
Yes.
drag out the deceased from the house, from
Yes.
his house, and brought him to the meeting place.
Who brought them then? Two persons dragged them and brought them. Then
The meeting was being convened in the middle of our village, in front of house of Dalaya Pidika and Narendra Pidika.
Yes.
The accused persons, Tanmay and Dumburi, assaulted the deceased by means of bamboo lathi, for which blood come out from his mouth.
so those two persons, Mr. Misra,
Yes, yes.
those two persons who dragged the deceased out of his house,
They assaulted.
they are the only persons who assaulted by means of bamboo lathi.
I understand.
Right. So the other two persons' participation or their
Silent.
presence even not stated by the other this PW3. That means whether in such a state of affair, those two persons' participation gone. But how can you say that the prosecution case is consistent in view of this type of evidence of the eyewitnesses? Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioners are in judicial custody since 12/11/2018, and as such, they have already undergone 4 years and 9 months of sentence out of 10 years imposed on them by the London trial court. The learned counsel further submits that though there are number of eyewitnesses to the occurrence, but their evidence is full of contradictions and no reliance can be placed on such evidence, and therefore there are good chances of success in the appeal and balance of convenience is in his favor. Learned counsel further submits that though PW1 stated that all the four accused persons entered into the house of the deceased, dragged him out of the house, and all the four assaulted the deceased by means of thenga. But PW3, another witness, has only implicated two of them to have dragged the deceased from the house and assaulted. The learned counsel submits that since there is no chance of early hearing of the appeal in the near future, therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that it's a case where after assault on the deceased died and the dead body was cremated, for which no post-mortem could be conducted. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced by the prosecution during trial, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, I'm inclined to release the petitioners on bail allowed. Stay relation of time. Yes.
Another prayer, item 89. On behalf of Mr. Oxygen, his mother is ill. He has left court from 1 week after.
Okay.
89. Oxygen.
Then also regarding the service of the appeal memo. Appeal mode of denials, let him.
I will inform.
Okay, item number 89, a mention is made on behalf of Asit Kumar Jena to adjourn the matter. The learned counsel for the state submits that he has not received the copy of the appeal memo along with the annexures. What is that 89? Is it a case of conviction or what is this? And impugned judgment and the interim applications copies. Let the learned counsel for the appellant supply the appeal memo along with the impugned judgment
Conviction.
and yes, conviction. and copies of the interim applications to the Land Council for the state. Matter will be listed in the week commencing from 7th August 2023. Defects shall be removed in the meantime.
Item 78.
Appeal against the rejection of the bail application.
Wait. 78 years. Is a bail application?
Yes, ma'am.
Not a case of conviction.
No, ma'am.
Okay. SC/ST matter or what?
No, my lord. Juvenile.
Juvenile matter. Yes, Mr. You have received the
Madam,
so what is his age?
the social investigation report was called for.
16 years, madam, at the time of occurrence.
This address is correct.
No, that has not been come, madam.
This is a man from Bihar.
Bihar, yes. That will be some more
So
time.
get that. What is there in that investigation report? Anything adverse?
CA, no, there is no CA, madam.
No CA. All right. You also because one of the person would be the family member if in case he is granted bail. The other would be the local surety. So you supply also the document to the Land and Council for the state in the meantime. The Land and Council for the state has produced the social investigation report, which indicates that there is no criminal antecedent against the appellant, and the same is taken on record. Land Council for the state, however, submitted that since the appellant belongs to district Vaishali in the state of Bihar, he may be given some time to verify whether the address furnished in the cause title is correct one or not. For such purpose, the superintendent of police so shall make, that is Navrangpur, shall make necessary communication with superintendent of police Vaishali district and obtain the written report to that effect. The Land Council for the petition appellant in the meantime shall furnish the names and address of the two local sureties to the Land Council for the state. Names, address, and documents which will be verified by the Land Council for the state through the inspector in charge of Navrangpur police station. Free copy of the order be handed over to the Land and Council for the state. Matter to be listed. It will let it come on 7th. Okay. 7/8/2023.
Let it be 14, madam.
14.
Madam.
So you supplied by if okay, by during course
You
of this
supplied
week.
directly to me, not in my office.
So let it come on 14th. Okay. Otherwise, again, if they will seek for time, so it will be. Yeah.
Item 90.
90 years, sir.
Matter may be taken up next week.
Next week. What is this criminal appeal for?
25 years
Conviction.
Conviction.
It's a condonation of delay.
Madam.
What is the delay?
Copy was served on 26/6/2023.
Copy of?
Extra copy because 370 AB is there.
Oh. So you have not served the extra copy?
Already copy served, madam.
It has been sent to the concerned.
Notice has been served on 26/6/2020. The order was passed on 22, my lord.
So nobody is appearing.
Nobody.
The delay is 146 days as per the. It is 25 years.
My lord.
25 crores.
All right, IA number 1214 of 2023. This is an application for condonation of delay. The Land and Council for the state submits that notice on the informant on limitation matter is sufficient. Since June 2023, none appears for the informant. Considering the submission made by the Land and Council for the respective parties, and since it's a case of conviction, and the Land and Trial Court has sentenced the appellant petitioner to arrive for 25 years, I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit. Call for the trial court record. Interim applications for bail and stay realization of fine shall be considered after receipt of the trial court record. Land Council for the appellant shall supply deposition copies
Already
of
supplied.
Already supplied. Cartesian, sir. Delay condone. Admit. Yes.
Item 100.
Yes, Mr. Panda.
100 by lot, they just have the deposition copy of 7 witnesses.
Yes, sir.
But it's filed the wakalatnama today. It may be taken on record, and I've filed the deposition copies.
Wakalatnama file kar लीजिए. Mr. Devasis Panda and his associates have filed wakalatnama for the appellant, which is taken on record. After obtaining consent from the previously engaged counsel, she is taken on record. Land Council for the state submits that he has received the deposition copies of the witnesses in court today from the Land and Council for the appellant, and the matter may be taken up next week, or you want a week after?
7th August.
7th, week after. List this matter on 7th August 2023.
I am for the informant.
The Land and Council for the informant is present. Mr. Das, because of the president's visit, there are some work has been assigned to us. So,
Item 101, SCST bill, I may have the copy to the hearing. That order may be passed so that item 101, SCST appeal.
101 extra copy of this.
SCST appeal, bail.
No, it's assigned single benches, so it's all right. So extra copy to be served.
Same is the case for item 102. It was a bail application, subsequently converted to appeal. Appeal memo ta debi and notice ta 100 section 15 ne jao.
Yes, a copy furnished to the Land Council for the state, item number 102 also.
My lord. Copy